too, yeah, that'd be perfect.
Wait, how are you?
And then, do we have to?
So then you can send them back to the school. I know in Puerto Rico that are interested, and people in New York might be interested. So let me see.
Mr. Suarez, what channel are you on?
I'll tell you that right now.
Abogados de Puerto Rico. So she knows what she did. On YouTube, go into YouTube, Convención de Abogados. So YouTube, if you're ready, it's on YouTube right now.
This is the future. Instead of bringing a paper, I'm bringing a computer.
Thank you very much for your appearances here today. What we'd like to do, as we did in the past, or done in the past, is ask the teams that are not competing to be outside, please. The lineup right now, the first two teams are Barry and St. John's, two Catholic schools, okay? Barry and St. John's team, would you please take the seats here?
Maybe see it. Good morning. Welcome to the moot court competition of the Puerto Rican Bar Association of Florida. I guess this is the national, and we're not here or arguments of counsel. You ready? Proceed? Are you ready? You may proceed. Pardon? I don't see one.
Maybe this is a mic here,
I
but
think that's the mic. Is it on?
I don't know if it's on the record.
Oh, that better? No.
Maybe it's better, right? So that they don't hear our voices.
Yeah, you may proceed.
Chief Justice, Associate Justices, may it please the court. My name is Jordan Benbow, and together with
Hold on a
my
second.
Oh, we don't have a clock. Time out.
I'm out. Rewind the clock. Who has the clock? Okay, so you can let us know. All right.
Thank you.
You may proceed.
Chief Justice, Associate Justices, may it please the court. My name is Jordan Benbow, and together with my co-counsel, Karen Chambers, we'll be representing the appellant, Mr. Homan. I will be
And what law firm are you from?
from Barry University.
That's what we know.
Huh?
That's what we know.
What? You know, because the brief, so I can ask questions regarding law that's in the brief. I don't know. Okay.
I will be addressing the first issue of local applicability, and my co-counsel, Mr. Chambers, will be addressing the second issue of substantive due process. We shall rest on our brief for the third issue due to time constraints. However, we are more than happy to entertain any questions in this report. This case is about upholding constitutional rights of the people of Puerto Rico, as set forth in their constitution, and therefore we respectfully request this court reverse the lower court's ruling. May I please reserve 1 minute for rebuttal?
You may.
Well, let me ask you a question before you proceed, if I may. You're the appellant, so you are claiming that there was error by the court below.
Yes, Your Honor.
Precisely what error, or it may be errors that the court committed below. What are you saying that the error was?
Your Honor, the contention is there are two errors in the court below. The first being that the statute, the Federal Death Penalty Act, is locally inapplicable as set forth in the Puerto Rican Federal Relations Act, and therefore Congress, for the second point, should have been clear and explicit if it wished its intent was to apply the FDPA to the Commonwealth of Puerto Rico.
Is it locally inapplicable because under the Puerto Rican Constitution, there shall be no death penalty, as it states in the Constitution of Puerto Rico?
Yes, Your Honor.
So that's the essence of your argument, that it is locally inapplicable, the FDPA, by reason of the fact that the Puerto Rican, the Commonwealth Constitution of Puerto Rico, prohibits the death penalty. That's basically the essence of your argument?
Yes, Your Honor, that's the core. However, it is read with the Puerto Rican Federal Relations Act, which Section 9 of the PRFRA, which was enacted prior to the approval of the Puerto Rican Constitution, is where the courts have gotten this locally inapplicable standard from. This is a federally enacted statute. It has created a compact between the Commonwealth of Puerto Rico and the federal government. Now, to your question, Your Honor, the Constitution itself is where the provision for the death penalty shall not exist is found. And reading the Puerto Rican Constitution together with the PRFRA, it is clear that the law is locally inapplicable. However, Congress can and has in the past extended Chaco v. Perez Rodriguez, another First Circuit case in 1967. The terminology that the courts used in both of those cases was that Congress unmistakably.
I thought federal law trumped any local law, state or territory or Commonwealth or otherwise. Is that not the rule?
No, it is, Your Honor,
Oh.
certainly. However, we have two federal laws conflicting in this case. We have the PRFRA, which is itself a federal law, and then we have the FEPA. They are both in controversy with each other. The FEPA can be applied to Puerto Rico as long as it complies with the PRFRA. It must do so in clear and explicit terms. Congress has not clearly provided that the FEPA applies to Puerto Rico.
Has it excluded?
No, Your Honor. However, this court should look at the plain language of the statute itself, that is the FEPA. And from the plain language, based on the canons of statutory interpretation, it is clear that Congress did not wish to extend the FEPA to Puerto Rico because they have done so in the past. They know the terminology to use for a federal law to apply above a constitutional provision. This was seen in the case of Quinones, in a First Circuit case. In Quinones, it was a wiretapping provision, and there was some controversy as to Title III provision in that case.
Well, in Quinones, really the issue was whether the evidence that was gotten by the wiretap could be used in a Puerto Rican court. The Puerto Rican argument was that it cannot be used because the Constitution prohibits that type of evidence. And that was really the issue there. Does the Constitution of Puerto Rico trumps, as Justice Perez has indicated, does it trump the wiretap law? That was really the issue in Quinones. And what did the Quinones court hold?
Your Honor, the court found that it did not because the First Circuit determined that
Did not what?
the wiretapping provision was not trumped by the local constitutional provision against wiretapping.
So that it was admissible evidence.
It was admissible, Your Honor, because the wiretapping statute was made explicitly applicable to Puerto Rico. It was only the Title III provision within the statute which was not. And the court was able to look at other parts of the statute to determine that Congress did indeed mean for it to apply to Puerto Rico.
But look, I think everyone here would agree that we can start from the premise that federal laws apply to Puerto Rico.
Yes, Your Honor.
Unless there are certain reasons why it cannot.
Time's up. Your time is
Okay, but you reserved
Oh,
some time. Go ahead.
yeah, we'll extend it. We'll give you a minute.
Thank you, Your Honor.
Okay. Well, answer the question.
Yeah.
What was your question, Your Honor?
The judge gave you permission to answer the question. That federal law applies to Puerto Rico.
Yes.
We all agreed on that.
Yes, Your Honor.
But you're saying that unless certain things occur, then it doesn't apply. For example, if it's not if it's locally inapplicable, then it doesn't apply. But then how do we determine whether it's locally inapplicable or not?
Your Honor, in this case, it is deemed locally applicable due to a constitutional provision which was approved by Congress.
But the problem that we have here is that it did not say, yes, Puerto Rico is excluded. It did not say, no, Puerto Rico is not excluded. So how do we determine whether it's applicable?
Your Honor, in the past, the First Circuit has always looked to the plain language or the congressional intent. And typically, the verbiage used by the court is that it was unmistakable and it's clearly expressed. In this case, it was not. Therefore, it should not apply.
So you say failure to expressly state that Puerto Rico is excluded means that it applies, or failure not to expressly say that Puerto Rico is not excluded, then it applies.
Yes, Your Honor. Failure to state clearly that it does apply.
Then it doesn't.
Isn't
The
implied.
FDPA, you're saying.
Yes.
So the FDPA, the bottom line is, does not clearly or unmistakably make it locally inapplicable.
Yes, and therefore, based on the PRFRA, it is locally inapplicable and does not apply. Thank you.
Okay. Thank you. Okay, let's hear the rebuttal to the appellant's argument. You're on the second argument.
The second issue is
All right, let's hear the rebuttal to the first so that we can better judge.
No pun intended.
No pun intended. Morning.
Good morning, Mr. Chief Justice. May it please the court. My name is Alicia Suarez. My name is Alicia Suarez, and I will be discussing the locally applicable issue here. The federal death penalty is locally applicable to Puerto Rico. The Puerto Rico Constitution was adopted in order to organize local government. It was not adopted in order to circumvent federal law. Therefore, this federal death penalty should be applied to the defendant in this case.
But you heard the argument by the other side that because it was not expressly stated in the FDPA that it would be applicable to Puerto Rico, therefore it cannot be applied to Puerto Rico. What do you say to that argument?
Well, in United States versus Quiñones and in United States versus Herrera, both times the wiretapping provision did not expressly include Puerto Rico, and the court found there that the Puerto Rican Constitution was adopted and the Federal Relations Act was adopted to apply to purely local matters. So what we must do is also look at the Federal Relations Act and the congressional history, as the appellant has stated. They do look at the congressional intent, and here we must actually look at the congressional intent of the Puerto Rican Relations
You're
Act.
saying that in Quiñones it was not Puerto Rico was not excluded, specifically excluded,
Correct.
but yet it was applicable.
Correct.
And you're saying in this particular case, Puerto Rico was.
Therefore, we can apply it. So a locally inapplicable matter would be a matter of purely local Puerto Rican charges, and not actually.
Well, but the argument is it's locally inapplicable because of the will of the people espoused in the Constitution prohibition against death penalty. So that has some kind of weight. Then you tie that with the fact that in this particular instance, the FDPA does not have a clear intent that it will be applicable to Puerto Rico. Therefore, the appellant is concluding that it's not locally applicable. How do you get around that? The tie-in with the Constitution and the tie-in with the lack of express intent.
I think, again, we have to look at the Federal Relations Act, the compact between the United States and Puerto Rico, and the purpose for allowing the Puerto Rican Constitution and for the people to come together and localize their government was to address local matters. Prior to the Federal Relations Act, Congress could come in and apply federal law to local matters. So the compact between Puerto Rico and the United States, along with the that ratified the Puerto Rican Constitution, was not there to address federal matters. It was there to address the purely local matters. So where the congressional intent does matter, we also have to look at the Federal Relations Act and Compact. And even though the federal death penalty does not expressly exclude or include Puerto Rico, it does expressly exclude Native American tribes. So we would have assumed that Congress would have expressly excluded Puerto Rico if its intent was to do so also.
3 minutes.
Okay. So
You're saying expressio unius alteris exclusio alterius?
yes, Your Honor. I believe that if Congress intended to also exclude another territory, it would have expressly done so within the Federal Relations Act. And here, it's only the Native American tribes that it felt to exclude.
And you would agree that expressio phrase is a Puerto Rican phrase, right?
We feel that the Puerto Rican Constitution was not adopted in order to circumvent federal laws. Thank you.
Thank you.
Thank you.
You may proceed.
May it please the court. I'm Darren Chambers, and I also represent the petitioner, Mr. Guerrero. This case is about federal death penalty application without representation. We respectfully request that this court reverse the first circuit's decision decision and hold that application of the FTPA petitioner does violate the substantive due process rights for the following two reasons. First, citizens of Puerto Rico do not have proper representation. And second, death is substantially different, and applying it to citizens of Puerto Rico violates it shocks the conscience. To my first reason, this court over and over again has stated that voting is a fundamental right that was in Cardona v. Powers. In Riddle v. Sims, this court says the right of suffrage is a fundamental matter in a free democratic society.
Do you think voting is a key issue here? Let me posit this scenario. It's a hypothetical, but I want to see how you will react to this situation. Let's say an American citizen who has lived in the United States all of his or her life, and therefore has had representation in Congress, temporarily moves to Puerto Rico, and for whatever the reason decides to commit a crime that comes under the FTPA. Would that person be able to make that argument? Because that person, through all his or her life, was in the United States and had the opportunity to vote and therefore be represented. Would that person make that Fifth Amendment substantive due process argument?
But yes, Your Honor, this right that extends to the citizens living on the island of Puerto Rico.
But this person had the right all of his or her life to be represented by Congress. So that person cannot argue that that law was passed without him or her being represented.
Yes, Your Honor. The difficulty there would be determining who's resided in Puerto Rico for the duration of their life and who's had representation, whether that representation was adequate. What we're asking here is that the Federal Death Penalty Act, since it violates substantive due process rights for petitioner and people of Puerto Rico who have not had representation, that right.
So in the scenario that I'm painting to you, you're saying that the dispositive fact is residence in Puerto Rico, not whether the person has lived all of his or her life in the United States and has had representation in Congress. So you're saying that the dispositive fact with respect to substantive due process is the fact of physical presence in Puerto Rico.
Your Honor, it would be difficult again to ascertain who's had the proper representation. For that matter, it's specifically to a petitioner who's resided in Puerto Rico his entire life, has not had representation.
And that's the case here. I was just throwing a scenario to see how you would look at the application of the Fifth Amendment substantive due process claim.
So are you saying that in its origin, ab initio, the Puerto Rico Federal Relations Act basically should be repealed, or somehow it's not applicable? Because back in the 50s, we didn't have representation in Congress either down in Puerto Rico. So I'm not quite getting what the argument is. In other words, today, so many years later, you're saying all of that happened back in the 50s is no good because it violates the substantive due process of the Puerto Ricans in Puerto Rico because they don't have representation in Congress.
No.
Well, they didn't have representation back in 1950 and 51 either.
And no time and type. It's the one penalty that is irreversible. It's final.
Well, if it's okay, so you're saying in Puerto Rico is because this death is different, that it shouldn't apply. Now, how would that juxtapose itself against the death penalty in other states that don't have a death penalty?
Your Honor, in Michigan, in their constitution, they have abolished the death penalty. But those states have had representation. Those states don't have the Puerto Rico.
What difference does representation make? If the federal code applies to the United States, correct?
Yes, sir.
And in the definition, Puerto Rico is included in the United States, correct?
Yes, sir.
So doesn't that indicate that Congress had an intent that all of the provisions of the code would be applicable to Puerto Rico?
Your Honor, it's the shocks of conscience standard which rules the violation of substantive due
Whose
process.
conscience are we shocking?
It's ours. It's people's. It's something that's so rooted in traditions and conscience. And in our traditions are the right to vote. That's fundamental.
Well, what if it shocks my conscience? Does that mean it doesn't apply to me?
I'm sorry, Your Honor.
It shocks my conscience. Does it mean it doesn't apply to me?
No, Your Honor. it's not set to the individual's conscience. It's set to the people's, our traditions, our culture. And our tradition as a country is that the fundamental right to vote is necessary in a free society. The peoples of Thank you, Andrew. The United States citizens do not have, in Puerto Rico, do not have that fundamental right to vote for the president who appoints the U.S. attorneys who seek the death penalty, to vote for members of Congress who vote for acts like the Federal Death Penalty Act and hold this act.
So you're saying Puerto Rico should have, if they had 5 representatives, they would overturn this?
No, Your Honor, but that would give them fair representation of vote in Congress to move legislation in one direction or another. It wouldn't be enough to change something, but it might have had an effect if they had that representation at the time the Federal Death Penalty Act was enacted. You know. And for these reasons, we respectfully request that this court reverse the first decision.
Thank you.
Thank you. Thank you.
You may proceed.
Thank you, Ryan. Good morning, Mr. Chief Justice, and may it please the court. My name is Ashley Aguilar, and I too represent the United States this morning. I will be discussing whether applying the federal death penalty to defendants violates the substantive due process. However, before I begin, I'd like to address 3 of my learned adversaries' points. To begin, it is true that voting is a fundamental right, and it is never this government's position to deprive someone of their right to vote. However, Puerto Ricans have voted to not have a vote in Congress. Secondly,
They have voted to do what?
they have voted to remain a commonwealth and not become a state. Thus, they've voted to remain the same.
But that's irrespective of whether they have voted not to join the United States and therefore vote in Congress. Does that mean then that the PRFRA, we're supposed to ignore it when it says that certain laws that will be passed by Congress will be locally inapplicable?
No, Your Honor, that is not what I'm arguing here. It's the United States government should and does recognize the Puerto Rican Federal Relations Act and all of its facets in Puerto Rico and its relationship to the United States. Secondly, I'd like to address the fact that death is different. And this government recognizes that death is qualitatively different. And notwithstanding the irrevocably grave nature of the death penalty, because the defendant is being charged with a federal crime like any other American citizen, here it is just not egregious enough to shock the conscience. Now, when we look to whether or not something is egregious, we look to whether it's so brutal and so offensive as to offend traditional notions of fair play and decency. And, Your Honors, that's simply not what we have here.
But your adversary's contention is not solely one or the other, meaning that we have not been given the right to vote and that the death penalty shocks the conscience. The way I understand his argument is that a combination of both is so bad that it violates the Fifth Amendment. And as you know, the Fifth Amendment simply says that no person shall be deprived of liberty, property, life, etc., without due process. And what they're saying is that there is no due process here because the person that is being affected by the deprivation of, in this case, of life, has not had the opportunity to voice something with respect to how that is going to affect them. And that's the argument there. Is that a valid argument that because we have not had the right, and when I say we, that's the argument of the appellant, we have had not the right to have a say-so as to
Essentially sentenced to death under the federal death penalty like any other American citizen. Similarly, if we look to City of Sacramento versus Lewis, there a driver was involved in a drunk driving accident, and while he was unconscious in the hospital, a doctor performed a drug test on him. And the driver was then convicted with that drug test. There, the court held that notwithstanding the fact that the patient did not consent to the drug test, that was not egregious enough to shock the conscience.
question is whether they can be equated, taking the life of someone versus taking blood from someone who's unconscious. reasonable people could differ that one is more egregious than the other, that one would shock the conscience. Actually, some people may even consider that taking blood out of an unconscious person may be may shock the conscience. But really the question is, are those similar so that the standard of shocking the conscience can be applied to both equally? That's really the issue.
There are two responses to your question. One, it is clear that taking blood and taking life are inherently different. The government does not equate taking blood and taking life, Your Honor, because death is different. And to the second point, Your Honor, the same court in the city of Sacramento versus Lewis held that what may be egregious in one instance might not be in another. Thus, the courts must conduct an exact analysis of all of the circumstances before they can hold whether something shocks the conscience.
But again, I go to the point that, of your opponent that he is not saying that shocks the conscience by itself may be enough. What I believe his argument is that in conjunction with the lack of an ability to vote on that combination shocks the conscience and is violative of the due process clause of the Fifth Amendment.
Your Honor, I understand your concern. However, the fact that Puerto Ricans do not have a vote in Congress is a political question here, and not for the courts to decide. However, notwithstanding their lack of voting representation in Congress, because Puerto Ricans have the same benefits and protections under the American Constitution as every other American citizen, they must be held to uphold the standards of that same Constitution, just like any other American citizen.
Except for the FRA, which sets certain limits.
Yes, Your Honor.
And that's really the question before us. Whether
I have a question for you, Counsel.
Yes, Your Honor.
The Puerto Rican Constitution explicitly states that there shall be no death penalty.
Yes, Your Honor.
Okay. So what if they just sentence Mr. Pujols to death, the judge down in Puerto Rico sentenced him to death, and then they just take him to Atlanta, Georgia, to a federal prison and execute him over there? He's not in Puerto Rico, so they're not really violating the terms of the Puerto Rican Constitution because they're not killing him in Puerto Rico. They're killing him in Atlanta.
Yes, Your Honor.
How
However,
about, in other words, the federal government would be respecting the Puerto Rican Constitution by not executing him in Puerto Rico, because Puerto Rico has a constitution that says there shall be no death penalty.
no, Your Honor. According to the Puerto Rican Federal Relations Act, statutes except hereinbefore or hereinafter provided for that are not locally applicable shall not apply. And since the crime occurred in Puerto Rico and he was sentenced to death in Puerto Rico, it would be a violation of the compact between Puerto Rico and the United States.
But that's not what the Puerto Rican Constitution says. If you read it literally, it says there shall be no death penalty. It doesn't say that somebody can't be sentenced to death. It just says that the penalty cannot be imposed. So, all the feds have to do is just transport the man to some other federal jurisdiction in the United States where they have a gas chamber or however they do it, or lethal injection, and just execute him, and therefore not in Puerto Rico. Time is up. No, but I'll allow the comment. Go ahead. Say it again. Tell me again how that doesn't basically cut into your essential argument that you made.
Thank you, Your Honor. The Puerto Rican Constitution, the spirit of the words, perhaps Your Honor's hypothetical explains the words themselves, but the spirit of the law is that the death penalty shall not apply to the Puerto Rican citizens as a whole. It would be illogical to apply a different meaning to those words. Thank you, Your Honor.
But now, if we agree with you, would not all of the criminals move down to Puerto Rico because they have the impunity? Don't have to worry about the death sentence.
Your Honor, it is not clear whether they would or not, and I am not in a position to state otherwise. However,
but maybe one way to look at it is whether the individual is killed in Puerto Rico or it's killed somewhere else in the United States, the bottom line is that the individual will be killed. First of all, will be facing the death penalty. And the death penalty is applied whether the individual gets killed in Puerto Rico or gets killed somewhere else in the United States. Bottom line is the individual gets killed in violation of what the defendant says is a law that is inapplicable to him.
No, Your Honor. If the crime was to occur within the United States.
No.
He's following up on my argument. Go ahead.
Yeah. Crime is committed in Puerto Rico. The individual gets convicted in Puerto Rico. Then the jury decides to implement the death penalty. What I am saying is it doesn't matter whether the individual.
Can they use this microphone?
No. That's
Mr. Chief Justice, may it please the court. Good morning, Your Honors. My name is Tamika Franco, and on behalf of the petitioner, Enrique Guerra Pujol, I will discuss why the Federal Death Penalty Act is inapplicable to Mr. Guerra Pujol and the people of Puerto Rico. Your Honors, the petitioner requests 1 minute for rebuttal. Thank you, Your Honors. Your Honors, the Federal Death Penalty Act is inapplicable to Mr. Guerra Pujol and the people of Puerto Rico for the following 3 reasons. First, the Federal Death Penalty Act is locally inapplicable to Puerto Rico under the Puerto Rican Federal Relations Act. Second, the Federal Death Penalty Act violates Mr. Guerra Pujol's substantive due process rights. And third, the Federal Death Penalty Act violates the International Covenant on Civil and Political Rights, a treaty ratified by Congress. Your Honors, for the foregoing reasons, the petitioner requests that you reverse the First Circuit's decision and hold that the Federal Death Penalty Act is inapplicable to Mr. Guerra Pujol and the people of Puerto Rico. To my first point, the Puerto Rican Federal Relations Act governs the relationship between the United States and Puerto Rico. It provides that all laws that are locally inapplicable to Puerto Rico have no force or effect in Puerto Rico. When Congress wants to make a law applicable to Puerto Rico, it does so through an express statement of applicability. This is found in the federal copyright laws of Title 17, and it provides that the laws are the federal copyright laws under Title 17. And the statement of applicability is for the 50 states, the District of Columbia, and the Commonwealth of Puerto Rico. There are other federal laws that have the same statement of applicability, including the Occupational Safety and Health Act, the Tariff Act, the Mann Act, the National Bank Act, the Bankruptcy Act. However, the Federal Death Penalty Act does not contain that same statement of applicability to Puerto Rico. Now,
does it contain any other similarly situated Commonwealth or territory?
No, the nature of Your Honor, the nature of Puerto Rico is different. And actually, in the congressional records, it shows that when Puerto Rico became a Commonwealth, one of the one of the congressmen stated that this is a unique situation because Puerto Rico is neither a state nor is it a territory. Now, under the Puerto Rican Federal Relations Act, when we're determining whether a federal law is applicable to locally inapplicable to Puerto Rico, Conti Marrero versus Colón Martinez says that we must look at congressional intent, especially when we have cases where there's no statement of applicability. In that case, the First Circuit found that the National Voters Registration Act was inapplicable to Puerto Rico because there was no express statement, and the court looked at congressional intent and found that Congress did not intend to apply that law to Puerto Rico.
Does every law that Congress passed has to say that it's applicable to Puerto Rico or not applicable to Puerto Rico to be applicable or implemented?
No, Your Honor. However, in this case and in Colón Marrero, the court found that there was no congressional intent. So the test is looking at congressional intent when there's no express statement. And in this...
How do you... Go ahead.
And how do we look at congressional intent?
Your Honor, by looking at the legislative history. And in this case, the Federal Death Penalty Act there are no findings that there is any intent by looking at the legislative history. Therefore, the Federal Death Penalty Act, just by looking at congressional intent, is inapplicable to Puerto Rico. Furthermore, under the Puerto Rican Federal Relations Act, there's no statement of applicability, no congressional intent. Therefore, the Federal Death Penalty Act is locally inapplicable to Puerto Rico. In addition, Puerto Rico's Constitution provides that the death penalty shall not exist. In 1950, Puerto Rico and the United States formed their relationship by way of a compact. The compact allowed Puerto Rico to create their own constitution. The people of Puerto Rico approved this compact.
Was that for...
Puerto Rico. First, the act did not exist. Second, Puerto Rico had already abolished the death penalty in a statute in 1929. So adding the provision in the Constitution just served as an expression to the United States that the death penalty shall not exist.
But that's within Puerto Rico. The Puerto Rican government would not sentence anybody to death. But how does that trump the federal?
Your Honor, I respectfully disagree. When the people added that provision in there, it was a signal to the United States because the people knew that the United States had the death penalty and Puerto Rico had already abolished the death penalty. So the agreement was the basis of the nature of the relationship between the United States and Puerto Rico. So it was just based on the agreement, and that is the Death Penalty Act is not what Puerto Rico agreed to.
But again, following up on Justice Ferrer's question, and I quote from Quiñones with respect to the Constitution and the relationship between the United States and Puerto Rico. The congressional intent behind the approval of the Puerto Rico Constitution was that the Constitution would operate to organize a local government, and its adoption would in no way alter the applicability of United States laws and federal jurisdiction in Puerto Rico. And that's a direct quote from Quiñones. How would you answer that, unless you think that Quiñones was wrongly decided?
Your Honor, I don't believe Quiñones was wrong. However, in applying the federal death penalty, when Puerto Rico had already abolished the death penalty within Puerto Rico internally, applying the Federal Death Penalty Act when the agreement between the United States and Puerto Rico says that the death penalty shall not exist, seeks to unilaterally amend Puerto Rico's constitution in its effect. And Mora versus Torres tells us that Congress is unable to unilaterally amend the agreement between the United States and Puerto Rico. And that is what is happening by the United States applying the Federal Death Penalty Act to Puerto Rico. Therefore, when dealing with something as extreme as the harsh consequence of death, we should not look at Congress's their failure to add a statement of applicability to Puerto Rico as a mere oversight. We should look at it as Congress's intent to exclude Puerto Rico from the act. Which brings me to my second point. Applying the Federal Death Penalty Act to Puerto Rico violates Mr. Guerra Pujol's substantive due process rights, and that's due to the lack of representation in Congress, and it violates the will of the people. The United States Constitution under the Fifth Amendment states that no man shall be deprived of life, liberty, or property without due process of law. Within the Due Process Clause flows substantive due process rights. The Due Process Clause guarantees substantive due process rights. It guarantees protected liberties within the word liberty in the Due Process Clause. From that flows a protection. It protects against governmental interference or the government infringing on the rights of the people. Mr. Guerra Pujol's substantive due process rights are being infringed on because there is a lack of representation in Congress. Due to the lack of representation, Mr. Guerra Pujol's rights are being violated, and the resident commissioner has no vote in Congress. So the people of Puerto Rico and Mr. Guerra Pujol have no way to voice their concerns or their opinions about the federal death penalty. The resident commissioner cannot vote yes or no to the Federal Death Penalty Act or any other laws that are applicable to Puerto Rico.
Now, if we agree with your argument, then wouldn't it be a wholesale migration to Puerto Rico to get Puerto Rican citizenship and let that be the center of all crime because you can't be sentenced to death? Because you're a resident there, you order murders to take place there and no consequences other than life imprisonment. Would we not be inviting that?
No, Your Honor, because under the substantive laws, there are additional punishments. Just the people of Puerto Rico ask not death. The death penalty shall not exist. So the people of Puerto Rico or anyone who would subsequently migrate to Puerto Rico because the death penalty wouldn't be enacted or be used, they would still know that they would be punishment. They can be subject to life in prison.
But death is different.
I agree, Your Honor. So although it's different, some would argue that life in prison is equivalent to death. However, we're violating the substantive due process rights of the people of Puerto Rico by inflicting death by execution when there's no representation in Congress. They have no voice, no vote. Which brings me to my third point. The Federal Death Penalty Act violates provisions of the International Covenant on Civil and Political Rights, which is
outside of our purview.
No, Your Honor.
Courts can make determinations on international treaties and covenants.
No, Your Honor. However, Mr. Guerra Pujol can invoke standing for the International Covenant on Civil and Political Rights. And when the United States signed this treaty, it signaled to the international community that it sought to comply with the provisions within the covenant.
What gives Mr. Pujol standing?
Your Honor, he has standing because there has been a harm. Article 25 of the International Covenant on Civil and Political Rights allows public access through the individual or their chosen representative. Mr. Guerra Pujol does not have access to the political process, the federal political process, because their resident commissioner is unable to vote, and Mr. Guerra Pujol is unable to vote in federal laws, on federal laws.
Assuming that you have overcome the obstacle of standing, what about the concept of whether the treaty is self-executing or not self-executing?
Your Honor, while the treaty is non-self-executing, the United States seeks, their goal or their aspiration is to follow the treaty. Furthermore, the Vienna Convention on the Law of Treaties under Article 18 provides that a state, being the United States, cannot enact a law that goes against the object or purpose of the law. In this case, by enacting the Federal Death Penalty Act, the United States is going against the object and the purpose of those laws. And in Article 6 of the International Covenant on Civil and Political Rights, it states that you have the right to life.
Well, have courts determined that it's self-executing or that it's non-self-executing?
The courts have determined that it is non-self-executing. However, in the United States. Your Honor, I see that my time has ended. May I briefly conclude?
You may.
Thank you. Your Honors, the Federal Death Penalty Act violates Mr. Guerra Pujol's substantive due process rights. It is locally inapplicable to Puerto Rico under the Puerto Rican Federal Relations Act, and it violates provisions of the International Covenant on Civil and Political Rights, a treaty that was ratified by the United States. Therefore, we ask that today you reverse the First Circuit's decision and hold that the Federal Death Penalty Act is locally inapplicable and inapplicable to Puerto Rico and Mr. Guerra Pujol. Thank you.
Thank you.
Thank you. Yeah, we have to have a standard by which we measure.
So, I just heard you both arguments. The first argument and the second argument. Yeah, if there's another third, next argument.
We'll find out. But we should have
You may proceed.
You may proceed, counsel.
Good morning, Your Honors. My name is Jesse Ramos, and together with my co-counsel, Catherine Caicedo, we represent the respondent in this case, the United States of America. Your Honors, this case is about whether Puerto Rico has the ability to select which federal laws and which federal punishments to apply to its people. Petitioner was charged and convicted under 2 federal criminal laws and sentenced to death. We ask that you affirm the First Circuit's decision and deny petitioner's motion to strike the death penalty sentence. There are 3 issues before the court today. I will be addressing the substantive due process issue, and my co-counsel will be addressing whether the federal death penalty is locally applicable to the people of Puerto Rico and whether there is standing to invoke the International Covenant on Civil and Political Rights. Your Honors, This is not a violation of substantive due process for two reasons. First, a fundamental right is not involved. As such, the United States has a rational basis for applying the federal death penalty in Puerto Rico.
What are they saying that? Are they saying that a fundamental right is involved? What is their claim that that which is the fundamental right involved?
Well, here we say the right to life.
That's not a fundamental right.
A fundamental right to life, it's not fundamental. The U.S. Constitution guarantees that no citizen shall be deprived of life, liberty, or property without due process of law.
So apparently it must be a fundamental right if you have to have due process in order to violate it.
Yes, it wouldn't be by itself, but yes, we would need also due process in order to respect the right to life.
I have to get it right. Are you saying that the right to life is not a fundamental right?
Correct.
Okay.
As such, Your Honors.
The right to life is not a fundamental right?
Not by itself, Your Honor. Here, the criminal justice system has always applied the death penalty. We've always applied it in our criminal justice system. What the founders were concerned about was the deprivation of life without due process. They wanted to ensure that no one would be unjustly deprived of life. They were more concerned with fairness with just the taking of a life.
So isn't the argument that because they concluded that the right to life is so fundamental that it cannot be violated unless there is due process, and if there's due process, obviously there's no violation. But I'm just throwing out to you this statement you're making that the right to life is not a fundamental right. If it were not so, why would then they go in the Constitution go out of the way to say, yeah, you can take that right to life, but only with due process? So don't you think that only with due process is a recognition, an implicit, maybe even explicit recognition that it is a fundamental right?
Well, we contend that the right to life without due process is what we want. What we mean to say is that there needs to be some due process. We allow for the death penalty in and of itself as long as there is actual due process. We're not saying that we're not going to have death penalty at all. It is going to exist, but we want to make sure that there is due process. If you considered it a fundamental right by itself, we wouldn't have the death penalty, but we do have it because we consider as long as we have due process here.
Isn't that what makes death different from other punishments? That there's a heightened sense of due process and protection of life necessary. That makes death different than other criminal statutes.
Yes, Your Honor. And here we can see that there was no unfairness as to the federal criminal convictions themselves. The record is silent as to any procedural issues at the criminal trial, such as any search and seizure issues that may have warranted a claim for unfairness. He had due process of law. He was tried and convicted in the lower court and sentenced to death. Here, Your Honors, because it's not a fundamental right, the government has a rational basis for applying the federal death penalty to the people of Puerto Rico. It's providing punishment for criminals.
I think the argument doesn't have to do with rational basis. It has to do with Puerto Rico's Constitution and the compacts that the United States ratified.
Yes, Your Honor. But here, when we see the law that is being applied to Puerto Rico, because we don't consider it a fundamental right, instead of using a strict scrutiny standard, we use a rational basis. And courts have accepted any reasons as to why it's being applied as long as it's legitimate and reasonable.
But what about the arguments that Puerto Rico's situation is unique and that their constitution that our Congress approved explicitly states they wouldn't have the death penalty?
Well, Your Honor, we contend that because federal law is supreme, ultimately Puerto Rico, what we said in the compact is that we would allow them to govern local issues, local laws, local concerns when it came to federal issues such as the death penalty and murder. The U.S. government would still be supreme. Here, the Congress have never gave up plenary powers The U.S. Constitution says that it gives Congress the authority to make all needful rules and regulations concerning any territory to the United States. Here, we treat Puerto Rico in the way we treat other non-states such as the District of Columbia. Although they ban capital punishment in their local laws, they're still nonetheless subject to federal criminal punishment.
But what are we to make when the Puerto Rican Constitution was adopted? Or
provisions concerning such matters as the applicability of the United States laws and federal judicial jurisdiction in Puerto Rico would remain in full force and effect. What this means is, yes, they gave Puerto Rico the chance to ban capital punishment in Puerto Rico, but ultimately federal law would still reign supreme in federal jurisdiction.
So you're saying they granted Puerto Rico's the right not to impose the death penalty on its citizens?
Your Honors, I see that my time is up.
Your time is up when I say it's up.
Yes, sir. Yes, Your Honor.
Did you hear
No flashes.
Did you hear the question?
Can you repeat the question, Your Honor?
It was a friendly. I was trying to throw you a softball.
Oh.
But basically, what that meant was that Congress allowed Puerto Rico not to enforce the death penalty on its local laws, but not the federal law.
That's correct, Your Honor. May I briefly conclude?
You may. Right.
We ask that the court affirm the First Circuit's decision and deny petitioner's motion to strike the death penalty.
Okay.
Thank you.
Thank you. You may proceed.
Good morning, Your Honors. My name is Catherine Caicedo. As my co-counsel said, I will be addressing whether the federal death penalty is locally applicable to the people of Puerto Rico and whether they're standing to invoke the ICCPR. First, the federal death penalty clearly applies to residents of Puerto Rico. There are several indications that Congress clearly intended for the FTPA to apply to Puerto Rico. First, the federal laws the petitioner was charged and convicted under, 924J and 1513, clearly permit the death penalty as punishment for their violation. The statute says, whoever is guilty of murder in the first degree shall be punished by death or by imprisonment for life. Second, the FTPA makes its sentencing provisions applicable upon conviction of any federal capital offense. The U.S. District Court for the District of Puerto Rico has original jurisdiction over all violations of federal criminal law. This indicates congressional intent that all violations of federal criminal laws would be enforced regardless of any contrary local law. The compact between the United States and Puerto Rico did not permit Puerto Rico to circumvent federal law based on its Commonwealth status.
Yeah, but what about the fact that the Congress approved the Constitution before it was actually implemented down in Puerto Rico?
Yes, Your Honors. When Congress approved Puerto Rico's Constitution, they indicated their willingness to allow Puerto Rico to govern on local laws. Since the laws that the petitioner violated are federal laws, federal criminal punishment still apply. In the United States, the capital punishment is a permissible punishment for a violation of these laws. There's ample indication that Congress envisioned that the FTPA would apply to federal cases in Puerto Rico, and no indication that Congress regarded the FTPA as locally inapplicable to Puerto Rico. This brings me to my second point, that applying the federal death penalty to Puerto Rico does not amount to a unilateral change to the Puerto Rican Constitution.
Does not amount to what?
A unilateral change to the Puerto Rican Constitution. When Puerto Rico agreed to become a Commonwealth of the United States, Puerto Rico was only given the right to create and enforce local laws. Congress never ceded the powers to the people of Puerto Rico to pick and choose which federal laws would apply to them. Congress's acceptance of Puerto Rico's Constitution, with the provision of capital punishment intact, indicated only its willingness to allow the people of Puerto Rico to decide that the death penalty would be prohibited for local offenses. And that decision is comparable to that made by the citizens of some states where the death penalty is inapplicable for local offenses, yet they're still subject to capital punishment.
What about the argument that Puerto Rico is unique to states or even territories, that it's a commonwealth? What makes that different?
Yes, Your Honor. In the compact that Puerto Rico made with the United States, Puerto Rico understood that all federal laws would still apply to its people.
Except for under Section 9.
The laws that are locally inapplicable have been very few, and the federal laws that the petitioner violated clearly.
To here is it pivots up around that particular section. That sure, Congress can pass all the laws, but however, it will not pass laws that are locally inapplicable. And the question is this locally inapplicable? If the answer is yes, Congress has unilaterally taken on itself to violate the compact. Obviously, if it's determined that it's not locally inapplicable, then Congress is not violating the compact. Here is Congress violating the compact by unilaterally making a law that is locally inapplicable to Puerto Rico.
Or is it locally inapplicable? That's the issue.
That's exactly right.
Well, Your Honors, Puerto Rico's lack of representation and participation in Congress is dictated by the United States Constitution. Puerto Rico is situated no differently than any other non-state, such as the District of Columbia, where federal capital cases are brought despite local laws banning capital punishment. In this case, Your Honors, the petitioner violated a federal law, and Puerto Rico never had the ability to refuse to enforce federal law.
Well, let me ask you this. Now, when the compact and the Constitution were approved by the United States, did the United States government ask Puerto Rico to delete certain things?
Yes, Your Honor.
Did Puerto Rico have the right to say, no, we don't want to delete it?
I'm not sure, Your Honor. In this case, however, it was made clear that all federal laws would apply to Puerto Rico. In not objecting to Puerto Rico's ban on the death penalty, all that Congress was doing was allowing them the power to prohibit it for violations of local offenses. For my third point, Your Honors, the petitioner does not have standing to invoke the ICCPR. The ICCPR is non-self-executing and does not grant standing. Congress has declared that Articles 1 through 27 of the ICCPR are non-self-executing, and treaties affect the United States law only if they're self-executing or otherwise given effect by congressional legislation. In conclusion, Your Honors, there has been no arbitrary deprivation of life because the record is silent as to whether there was any inappropriate conduct relating to the criminal trial. The petitioner was charged and convicted under 2 federal statutes that clearly allow for the death penalty. The petitioner has no standing to invoke the ICCPR, and there has been no violation of due process. For these reasons, we respectfully request that you affirm the lower court's decision denying the petitioner's motion to strike the death penalty.
Thank you.
Thank you.
May it please the court.
You again? You arguing both sides?
This is rebuttal.
Oh, okay.
Your Honors, today the respondent is confusing the issues. The issue here today is that Mr. Guerra-Pujol's substantive due process rights are violated due to lack of representation in Congress. And in situations where there is death, as this court mentioned, death is different. In Reed versus Covert, this court stated that, Justice Harlan's concurring opinion stated that there are unique substantive due process concerns in capital cases.
Which case is this? I'm sorry?
Reed versus Covert.
What year was that?
1952.
Because there were 2 Harlams, you know.
Yes.
Yeah, okay.
Justice Harlan stated that there are unique substantive due process concerns in capital cases because death is different. And today, the petitioner seeks to remind the court that death is different. The respondent also likens Puerto Rico to a state, which Puerto Rico is not. So, Your Honor, I see that my time is up. For the foregoing...
You can finish your sentence.
Thank you.
Not another one.
Puerto Rico is not a state. Therefore, Puerto Rico cannot be treated as a state and be subjected to federal laws. Your Honor, for the foregoing reasons, I'd like to just remind you that the petitioner would request that the First Circuit's decision be reversed and that the Federal Death Penalty Act be held that it's not applicable to Puerto Rico and Mr. Guerra Pujol. Thank you.
Thank you.
Is your pen? Everything good?
Yep.
So are they done?
Your side done? Everyone's done?
Everyone is
Yep.
done.
Okay.
In this
Oh,
round,
okay.
in this round, very well.
So you argue all,
Okay.
then I said that.
Thank you.
Thank you.
All rise.
Court is in recess. We need to take the breaks now to use the restroom. This would be a good time as we switch out.
Okay.
If anyone needs to use the restroom, this is the time to do it. Okay.
Okay, you may proceed.
Good morning, Chief Justice, Your Honors. May it please the Court. My name is Francesca Caminero from Northern Southeastern University, and
You're not supposed to tell us where you're from.
they asked me to tell you.
Oh, really?
Yes.
Okay. All right then.
And I, along with my co-counsel, Zarina St. Lawrence, represent the appellant in this case. I will be speaking for 13 minutes, addressing all issues, and reserving 2 minutes for rebuttal. Your Honors, this is a case where the application of the death penalty is contrary to the culture, traditions, and values of the Puerto Rican people. We respectfully ask this court to reverse the ruling of the First Circuit Court of Appeals because to hold otherwise would be contrary to the culture, traditions, and values of the Puerto Rican people. Your Honor, the ruling of the First Circuit Court of Appeals should be denied for the following 2 reasons. First, the appellant does have standing to invoke the International Covenant on Civil and Political Rights, known as the ICCPR. Second, the Federal Death Penalty Act is locally inapplicable to Puerto Rico due to express prohibition of the death penalty in the Puerto Rican Constitution and due to the lack of representation the people experience in Congress.
Well, address the intent of Congress in passing this Federal Death Penalty Act. Did that explicitly exclude Puerto Rico?
Yes, because it did not address Puerto Rico in it. It was silent on that.
So it's implicit.
Yes.
Who decides whether it's locally inapplicable now?
The Congress does, Your Honor.
Go ahead.
Your Honor, would you like a brief
I'm sorry. Before you go further, again, following up on Justice Perry's question, Puerto Rico was not specifically excluded, was it, from the FDPA?
The Puerto Rico was excluded.
It was not included and it was not excluded.
Correct,
right?
Your Honor.
Now, were there any other entities that were excluded or not excluded?
That is, I'm not aware of that.
Where I'm going with that is, were the Native American tribes excluded from the application of the FDPA?
From my understanding, they were not.
They were not excluded.
They were not excluded.
Okay. If I were to tell you, and I'm not saying that I'm right,
Okay.
that they were excluded, specifically meaning that the FDPA would not apply to a crime committed in the Indian nation. If I were to tell you that, and that they were explicitly excluded, and Puerto Rico was not, if that were the case, what would that say with respect to the intent of Congress?
It would say, that, Your Honor, that the intent of Congress was to exclude the Indian tribe, but not Puerto Rico, because they wanted to apply to Puerto Rico then as a commonwealth, because the Indian tribe.
So the intent, you would say that if that's the case, and I'm not saying that if that were the case, then you would say that the intent of Congress in that instance would be to include Puerto Rico under the FDPA.
If it was silent on
Puerto Rico, but expressly excluding the Indian tribes.
Your
I
Honor,
don't want to say Indian tribes, the Native American tribes.
Your Honor, then the Puerto Rican people would take that as an understanding that Puerto Rico is excluded from it.
But you're arguing
if they did not include Puerto Rico specifically, if I'm understanding the question correctly.
No, I think you said they excluded the Native Americans.
But included Puerto Rico?
No, they were silent. They said nothing about Puerto Rico.
Then from my understanding, Your Honor, it would be that it does not apply to Puerto Rico if it is silent on Puerto Rico.
So it wouldn't matter what they said about the sovereign nations of the Native Americans?
Correct, Your Honor.
It wouldn't matter?
It would not matter, and...
Well, under statutory construction, wouldn't it mean that they knew how to exclude and everybody else is included?
I'm sorry, can you rephrase your question, Your Honor?
Under statutory construction, if they excluded the Native Americans on one hand and did not say anything about anybody else, that everybody else is included?
If they exclude CPR and the United States is obligated to interpret its laws in accordance with international law whenever possible, according to the Charming Betsy Doctrine, which says, an act of Congress ought never to be construed to violate the law of nations if any other possible construction remains. Therefore, Your Honors, by passing the Federal Death Penalty Act and trying to implement the death penalty onto the island, when the people of Puerto Rico have specifically expressed they don't want the death penalty, is in violation of the ICCPR, which the United States signed on to, with the intent to abide by it. The purpose of the ICCPR is to respect civil and political rights of individuals, including the right to life. Article 1 of the ICCPR states that, quote, all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Self-determination is an inherent right and a foundational principle of international law. The Constitution of the United States was created by our founding fathers to instill values and order in our country by permitting certain actions and placing limitations on other actions.
Now this ICCPR, were the courts strictly prohibited from interpreting that?
I'm sorry, I didn't quite understand
Wasn't
the question.
that taken out of the purview of the courts?
Correct, Your Honor. But under the Vienna Convention, under Article 18, a state is obligated to refrain from acts which would defeat the object and the purpose of a treaty when it has signed the treaty. And the purpose of the ICCPR is to protect the civil and human rights of individuals. So the intent of the United States when they signed the ICCPR was to abide by it.
Well, did not the ICCPR state that a signatory to that, if they already had the death penalty, were not required to abolish it, to make sure that death is different, that it be held to higher scrutiny?
Correct, Your Honor, but...
Did Puerto Rico sign that?
They did. The ICCPR? Yes.
Okay.
But it goes back to the intent and the purpose of the treaty. Although the United States did hold reservations to it, they signed on to it. And also when they ratified the Puerto Rican Constitution, they did not eliminate the Article 2, Section 7.
Now, was not that provision in the Puerto Rican Constitution peculiar to Puerto Rico only? They said it's okay for Puerto Rico not to have a death penalty?
Yes, Your Honor.
But did they also say that the United States could not have it?
It did not specifically state that about other states.
Well, doesn't the federal trump the local, what do you call them, territory, commonwealth, or state?
Yes, Your Honor. Federal law does trump state laws, but it goes back to the intent and the purpose of the treaty and the Constitution. The United States signed on to they ratified the Puerto Rican Constitution, and they had the ability to eliminate that article, and they decided...
Well, they didn't eliminate the article as it pertained to Puerto Rico, internally.
Correct, Your Honor.
Federal law is external to Puerto Rico, is it not?
Correct, but the crime that was committed in Puerto Rico.
Well, isn't Puerto Rico, for all intents and purposes, a part of the United States?
Well, it is not a state. It does not enjoy...
I said a part of the United States.
Yes, a commonwealth.
Although it's not a state.
Yes.
But it's a
yes.
part of the United States.
Correct, Your Honor.
And the citizens are citizens of the United States?
Yes, Your Honor.
Okay.
But they do not enjoy all of the federal representation that everyone else in the other 50 states enjoy.
But they do enjoy the right to be killed by the United States.
Not necessarily, Your Honor. Only because the Puerto Rican people are extremely against the death penalty.
Well, most people who the death penalty is imposed against are against it.
Correct, but it would go under the cruel and unusual punishment if they are sentenced to death, and it does go forward because if they are sentenced to death, they would have to be sent from Puerto Rico, obviously because they cannot be killed in Puerto Rico, to the United States, in a jail where they have no family that can come and visit them. They are in a different country and they have to wait who knows how many years before they are actually killed. So that falls.
Isn't that the same argument you made for any state in the United States?
I'm sorry, can you repeat that?
Can't the argument be made for any state in the United States that doesn't have a death penalty?
Not necessarily, Your Honor, because it is sometimes a little more difficult for people to come from a Caribbean island into the United States, not because of difficulties document-wise, but distance-wise.
So it's cruel and unusual because the family cannot come to see them before they die. Is that what you're telling me?
In certain terms, yes, Your Honor.
And that to obviate the death sentence for residents and citizens of Puerto Rico.
Well, Your Honor, it goes back to the culture and historical.
Puerto Rico, representing the government of the United States of America. I would like to reserve 3 minutes for rebuttal.
Okay.
May you please report?
You may proceed.
This case is about that. The violent killing of an innocent person, providing aid to our justice system. This case is about the violation of our most sacred right, life. And the crimes for which the petitioner is being accused clearly state death as punishment under sections 921 of U.S.C. Code 18, which rule sections 924 for the killing of a person with a firearm in relation to a violent crime. The Federal Death Penalty Act is locally applicable to Puerto Rico. In reality, whether a law is locally inapplicable under Section 9 of the Puerto Rican Federal Relations Act is a matter of congressional intent. Was Congress silent about the application of the death penalty in Puerto Rico? The answer is no. As we stated, also in the sections 1111 of the Federal Murder Rule, which governs the sections 1513 of killing a witness of state, also says it applies to Puerto Rico territories, maritime territories. With all due respect, Sister Counsel is misleading the court because Congress did exclude Indian tribes, American Indian tribes, on sections 3598 of the Death Penalty Act.
So the Native American tribes were specifically excluded?
Yes, Your Honor.
So what do you conclude from that vis-a-vis Puerto Rico?
The logical conclusion is that the act was legislated by Congress to apply to everyone in the United States, the 50 states, except the Indian tribes.
But isn't it, cannot the argument be made that Indian tribes and the United States, they're sovereign nations? Because the Native American tribes are considered sovereign nations. So that relationship may be considered with the relationship that Puerto Rico has with the United States, which is not on a sovereign nation basis, but rather on a compact. Would that make a difference to you?
Well,
that one would be excluded because they're sovereign nations, and one would not be stated because it's considered part of the United States, and therefore it will include Puerto Rico. Why cannot that argument be made?
I don't know if I'm saying correctly.
Very simple. The reason the argument could be made why the Native American tribes were excluded is because they're sovereign nations. Both Puerto Rico and the United States are not sovereign nations. Puerto Rico is under the tutelage of the United States. So therefore, they went out of their way to explicitly exclude the Native American tribes but they felt that they did not need to go out of their way to explicitly exclude Puerto Rico because Puerto Rico is not a sovereign nation, but rather part of the United States federal system.
Well, the first part of the argument, I will agree to that. But the last part, since 1920s, the insular cases stated that Puerto Rico belongs to the United States. It's not part. We've been treated, Puerto Ricans are being treated differently from the rest of the United States and from the same compact that they both agreed on. So I will understand that the reason that it was the Indian tribes that were excluded is because, yes, they were a sovereign nation, and Puerto Ricans are not. And that will, and I think that will follow our argument, and that there was an exclusion of the Indian tribes. Congress could exclude Puerto Rico, and there has been times that Congress also could have had the opportunity to exclude, for example, the Wiretap Act, that it was also applicable to Puerto Rico, even when it was included a prohibition of it in our Constitution.
Yeah, but you're going away from the argument that because the Native American tribes were excluded and Puerto Rico was not mentioned, it meant that Puerto Rico therefore would be included in the FTPA.
Yeah.
Okay.
Well, Your Honor, we will have to revise that statute, but it goes away from our controversy right now. We would like to state that in the Fifth Amendment of the United States, it does mention capital punishment, and the due process clause is made so people can be deprived of life, liberty, and property, but with some measurements to improve the justice system and some safeguards.
No words.
So you're saying that because Mr. Pujols is not claiming that in his trial there was no violation of his due process rights, therefore the imposition of the death penalty to him would not apply because he's not claiming that his trial was devoid of due process. The conviction itself was not in violation of his due process rights, therefore the sentence is permissible.
We do think that there was not a...
That was a friendly question.
What?
That was a friendly response.
Yes. Yeah, it was.
What you should say is, I heartily agree with you, Judge.
Heartily agree.
Okay.
Thank you.
Is that it?
You done?
No.
3 minutes.
3 minutes.
It's just beginning.
What's that? Oh, this is a rebuttal.
Well, I would like them to refer to some of the statements that were made by Sister Costa.
Okay.
Congress, there's been times when the Congress, besides the white that I was applying for, Congress has applied laws even when it hasn't expressed that it is included, Puerto Rico was included. There's been times when Congress has even applied federal law when even those laws don't apply to local states. That happened with the Buy American law in a case from 2012.
What happened there?
The clause of Buy American Act was applied to Puerto Rico in a case when it decided that even if it wasn't permitted even if it didn't apply to federal local states, it did apply to Puerto Rico. Since the International Covenant of Civil and Political Rights, like you were saying, does not have an extraterritorial clause, and Congress has not legislated to make itself executable, the petitioner does not have standing to invoke the International Covenant of Civil and Political Rights that Councilor was stated before. Third, Your Honors, we just want to impose what is the rule of law. We don't want Puerto Ricans to be treated different as the different the 50 states. We want to apply federal law and federal jurisdiction to United States citizens that belong to the United States.
Thank you very much. You may proceed.
May it please the Court, Your Honors, I would just like to address a few points. All domestic law must be interpreted consistently with international obligations to which the United States is a party when possible. This Court held that the Charming Betsy Doctrine created presumptions that Congress did not intend to pass statutes that violate international law or pass statutes that violate treaty obligations. Whereas
is of national importance. As far as the International Convention of Civil and Political Rights, when Congress ratified it, it was with the reservations that Articles 1 through 27 are not self-executing. Those reservations were accepted. The majority of the signatory parties did not have any issues with those declarations, and therefore the United States is not violating the International Convention of Civil and Political Rights. For this reason, we ask the court to affirm the lower court and apply the federal death penalty to Puerto Rico. Thank you.
Thank you.
Thank you.
Are we done? We're done. Very well. Thank you.
Thank you.
All rise.
Maybe excuse.
I got a muffin too.
That's right.
This is going to be the last argument this morning, because we have one after this. But since the lunch is at 12, well, what we're doing is we're going to have the last argument today, we're going to do right at 1 o'clock.
Okay.
After lunch.
After lunch.
Right.
Oh, okay.
And then that way it goes back on some sort of schedule.
We can't do 2 more
No, this morning.
because we've got to be there at 12. Oh, be there. Let's do it.
Are we good? Let's go.
I'm in heaven.
So this evening, all right, go
Last year we did it.
We'll push it. Let's push it.
Okay, let's do it.
Ready?
Okay.
Ready.
Are you ready to proceed?
Court is in session.
You may be seated.
Chief Justice, and may it please the court, my name is Christopher Rivera, and I am representing the petitioner in this present matter. I ask for the court's time to reserve 3 minutes in rebuttal.
Yes.
Okay.
Your Honors, my client stands accused of crimes punishable under the Federal Death Penalty Act of 1994. District Court, by the voice of Judge Casellas, held that under Section 9 of the Federal Relations Act, the federal death penalty is in fact locally inapplicable. Subsequently, Judge Lynch of the First Circuit reversed Judge Casellas' ruling, understanding that there was congressional intention.
We understand the procedural aspect. Why don't you just cut to the chase?
Okay, sure. Your Honors, we intend to argue that the opinion of Judge Lynch of the First Circuit was erroneous due to the fact that he relied solely on congressional intent to apply federal law that was not explicitly applied by Congress. We intend to argue and propose to the Honorable Court the adoption of the Cordova test based
The what test?
the Cordova test based on Cordova versus Chase Manhattan.
I didn't get that.
I'm sorry. On page 27 of my brief, you'll find our proposal of the adoption of the Cordova test based
Cordovan?
Cordova.
Cordova.
Yeah, Cordova.
Got it. Okay.
Thank you, Your Honors.
Okay.
In Cordova versus Chase Manhattan, Judge Bray explains to us that congressional intention must be based on specific evidence and a clear public policy. If it is not explicit. Senator Foraker's intention by using the local inapplicability phrase in Section 9 is precisely to use economical factors, social, economical, historical factors, and other self-government emerging considerations. Taking this in fact, we intend to argue 5 different points, which we respectfully ask the court to ponder them one on top of the other in order to apply it to the Cordova test as stated in page 27 of my brief, in order to arrive at the conclusion that it is locally inapplicable.
So are you saying that the federal courts have to specifically look at the historical perspective of the death penalty in Puerto Rico, look at the local compact, what happened between the federal government and Puerto Rico,
Exactly.
the fact that the Constitution of Puerto Rico says that the death penalty shall not be applied or does not exist. In other words, and not just say that because it's applied to the states, it's applied to Puerto Rico or something like that.
Exactly.
You have to actually delve into the specifics.
Specifically, we are not arguing that Congress has the power to apply federal statutes to Puerto Rico, but there are limits. In Section 9, the limit is locally inapplicable. In order to take locally inapplicable into consideration, I ask this honorable court to ponder 5 different points, of which the first one would be lack of representation of the people of Puerto Rico in Congress. Secondly, would be the nature and the compact in which the Constitution of Puerto Rico was constructed upon. Thirdly, the total inexistence of the death penalty in Puerto Rico as of actively. Fourthly, the historical repugnance of the people of Puerto Rico. And fifthly, the standing that my client should be afforded under the International Covenant on Civil and Political Rights. First of all, lack of representation alone, Your Honors, is a crass violation of substantive due process. And I explain myself. People of Puerto Rico have no representation whatsoever. We only have one commissioner resident who has a right to be heard, but has no right to vote. Your Honors, I think we can agree that a voice without a vote is not really a voice.
Well, wouldn't that be applicable to all federal laws?
No, Your Honor. The proposition of the court of attest, as I stated in my brief, is precisely that when there is a problem of congressional intention towards the application of a federal statute towards Puerto Rico, and it is not clear on its intention, then we must interpret it under the section. This honorable court should interpret it under Section 9 of the Federal Relations Act. We understand that the substantive due process that is being violated of the people of Puerto Rico can be mitigated by the adoption of the proposed court of attest, because this honorable court can afford the people of Puerto Rico, the U.S. citizens residing in Puerto Rico, that substantive due process that is lacking as of right now. See, the people of Puerto Rico had no say whatsoever, and the application of the Federal Death Penalty Act in Puerto Rico, and it's precisely prohibited, and not only prohibited, it's totally in existence. It is stated in our Constitution.
So basically what you're saying is that Congress has to ask permission from Puerto Rico before they can impose a federal law down there.
No, Your Honor. What I specifically mean to say is that Congress entered in a compact, and this is my second argument. Congress entered in the nature of a compact in the Constitution of Puerto Rico. The people of Puerto Rico have an expectation that the compact that was agreed upon, that specifically states that death penalty shall not exist, would be upheld. Of course, yes, Your Honor.
But does that give the holistic application to all of the federal statutes?
No, Your Honor. We understand that this is not the case, but we do argue that by applying the Federal Death Penalty Act in Puerto Rico without specific evidence or a clear public policy to do so, without the consent of Puerto Rico, is in violation of the very compact, which is the Constitution of Puerto Rico. You see, Your Honor, the people of Puerto Rico had an expectation that the bilateral agreement, which is the Constitution of Puerto Rico, would be upheld by both sides. You see, Your Honor, the compact has been stated by various
Isn't it upheld if the United States respects the government of Puerto Rico to impose the death penalty as it sees fit? Even if the United States government, under the Supremacy Clause, applies it holistically to all the citizens of the United States?
Sure, Your Honor, and we do not argue that the Supremacy Clause does not apply to Puerto Rico, but we do argue that the Supremacy Clause does not apply, that Congress cannot apply every law if it's locally inapplicable. And I explain myself. Combs versus Virginia, Justice Marshall explains to us that Supremacy Clause, that states cannot oppose the application of federal statutes due to the fact that they are represented in Congress. People of Puerto Rico are not afforded this representation, Your Honor. So under the Constitution of Puerto Rico being a bilateral
when Puerto
compact,
Rico entered into the compact with the United States, Puerto Rico was aware that it had zero representation in the U.S. Congress. And the PRFRA states under Section 9 that all federal laws will apply to Puerto Rico except those that are locally inapplicable. When the FDPA was enacted, there was explicit language precluding the application of the statute to the American Native tribes, American Indian tribes, American Native tribes, Native American tribes. They were explicitly left out.
yes,
But guess what? Puerto Rico was not left out. So under the statutory construction method by Murphy, was it that who taught us? Professor Murphy. It says that expressio unius exclusio alterius. That's a Puerto Rican phrase.
Yeah.
It means that the express inclusion of one is the exclusion of the other. But in this case, the fact that Congress explicitly kept out the American Native American tribes. Okay. Think about the
You
rest.
have a minute.
The rest.
Your Honor, if I may.
He went back on his word because before he told me it was a minute and a half.
All right, you can get a minute.
So.
Yes, Your Honor.
Yeah.
We understand that the exclusion of the Indian Americans is
exclusion.
The exclusion, yes, is explicit and it's expressly excluded. We understand that this is a double standard, Your Honor, because the exclusion of the Indian Americans was precisely for the same reason. You see, Your Honor, Indian Americans have no representation in Congress either. Now, upon the construction of statutes,
you argue equal
of course, Your Honor.
But
They should have explicitly
we're
stated.
talking about the statute right now.
Yes, sure.
If they were excluded, then if the Congress' intent was to exclude Puerto Rico, it would have. They know how to exclude. We established that, right?
Of course, Your Honor. We understand, but under the construction of, if I may finish my argument.
You may finish.
Thank you. Under the construction process, we must assume that Congress did so in accordance to its constituents. The constituents of Puerto Rico hold under Article 2, Section 7 that the death penalty will not exist in Puerto Rico. Hence, Congress, we must assume, this honorable court must assume that it did so understanding that the Constitution, that the constituents in Puerto Rico are opposed to the death penalty and cannot be arrived at the assumption that they did so wanting to include.
Okay.
Thank you, Your Honor.
Thank you.
Thank you. Something like a rebut.
Well, we want the ones who are going to rebut the opposite side of the appellee on that particular issue come next. Is that you?
No, we actually did not save any time for rebuttal as respondent.
No, I mean the opposition argument.
Sure. If
The
you'd like to.
opposition in chief to the argument we just heard.
Okay.
We don't know who that is. You know. Is it?
Well, we're working together. We're a combo.
Oh, you together? Oh, okay.
Yeah.
You may be first.
So whoever has the argument in chief against what we just heard, then that should be the next person to.
Okay.
Right?
Your Honor,
Yeah, right.
Your Honor, petitioner mentioned the establishment of the Cordova test.
So you're the one, right?
Yes. Well.
You may be seated. Okay.
Your Honor, the petitioner mentioned the establishment of the Cordova test. Just to clarify, the Cordova case is non-binding, and therefore this test doesn't exist.
Why is it not binding?
It's not binding because there's ample evidence already, and we'll go into this when we go into our argument, but there's ample evidence already of how this matter should be settled. For example, we have the Ecosa Martinez case from the First Circuit, as well as more recent cases that align how both the lower courts and the appellate level are addressing this issue. So for instance, in 2012, the Federal District Court saw a case under the defendant of Burgos Montes, where they also saw a defendant being charged under Section 1513A1B, which relates to murdering someone for retaliation for participating and cooperating with federal law enforcement. And in that case, the Attorney General also was able to authorize the federal death penalty as a potential punishment. Therefore, what we see is that there is an alignment.
What jurisdiction was that?
It was under Puerto Rico.
All right.
It was in Puerto Rico. So we see that not only at the circuit level with Ecosa Martinez in 2001, but also in subsequent cases at the lower district level, we see a consistency, and given stare decisis and the principles that this court entertains, the Cordova test would fail. Thank you.
So the other counsel is going to complete the argument against the. Yeah, ask him.
Are you? Was that? Were you the rebuttal?
Yeah, I was part of it.
Is that this is one of those circumstances under Section 9 of the PRFRA that Congress will not pass a law that is locally inapplicable to Puerto Rico. And the question is this locally inapplicable?
No, Your Honor, this law is locally applicable for several reasons. First, if we look to Mercado, the case establishes a clear default rule. As you mentioned, laws, and Federalism 101 will tell us that federal laws do apply in territories. So for example, even if we look to...
But you have a concept.
They said Puerto Rico is not a territory, it's a commonwealth, which makes that different.
Yes, Your Honor, but if we look, for instance, to the 1976 case of examining board, where the case looks at this issue specifically within a different context, but I think it informs our understanding of the FDPA. There, the court focused on whether the aims of the statute that was in question would be different in Puerto Rico versus in the United States. And what we would argue is that there's a clear public policy interest from a federal level to protect civilians against heinous violent crimes. Therefore, protecting a victim in Puerto Rico is no different than protecting a victim who suffers from the same crime in the United States.
But it has to be done within the prescription of Section 9. And that's really the question. No one is arguing that they have the right to protect Puerto Rico from, or Puerto Rican citizens from heinous crimes. No one is arguing that. The question is, can they do this pursuant to the compact?
Yes, they can, Your Honor. If we look closely at Section 9, what Section 9 says is the statutory laws of the United States, not locally inapplicable, shall have the same force and effect in Puerto Rico and the United States.
But the key is not locally inapplicable, and they're saying that this is one of those. And in part for two reasons, because the intent of Congress was not clear as to whether it would apply to Puerto Rico, number one. And number two, that there is a constitution in Puerto Rico that abolishes or not abolish it, but that states clearly that it shall not exist. And number three, Congress had the opportunity when the Constitution was submitted to it for approval, and they rejected certain parts of the Constitution, yet they failed to address or touch or request that, I think it's Section 7 of the Constitution,
yes, Your Honor,
be taken out. So that's,
well, Your Honor,
that's the hurdle you have to overcome.
If you look at both of the statutes of 924J and 1513A1B, if we look at the Acosta Martinez case, it expressly says that it applies to Puerto Rico. And if we're looking at
the
crime,
FDPA?
For victims to be compensated and to feel that their justice system is really hearing their voices.
So you're saying that death will compensate victims?
No, Your Honor. What I'm saying is that we need to apply the laws uniformly, and in order to do that across the United States and not just provide preferential treatment to certain jurisdictions, you have to be able to have that option in place.
But address Puerto Rico's constitutional provision that prohibits death sentences as juxtaposed to the federal Death Penalty Act. How does that interact?
Your Honor, it's an issue of federal preemption. So we're looking at state
of
federal preemption.
Federal preemption.
Federalism 101, we all take it in law school, will tell you that federal law will trump state or local law. In this case, given the importance at a national level of protecting our civilians, we need to have something like this in place, and therefore it takes it out of the box of locally inapplicable. For example, something that would kind of help in terms of seeing where the congressional intent fits and where the federal interest fits is maybe something like an analogy with what's happening with carjackings in Puerto Rico right now. As of May 2012, carjackings are included within federal jurisdiction, even though it's something that one could consider to be a local issue. Therefore, if we think about how violent crimes are moving into the federal jurisdiction, and think about the fact that there isn't a specific exclusion under the FDPA for Puerto Rico, and include that also within the idea of all of the precedent that we've had so far, the natural conclusion is that the court should uphold the application of the FDPA in Puerto Rico. Furthermore, if we look at the issue, the petitioner mentioned the ICPR. There's actually a carve-out in the ICPR for the application of the death penalty, so that issue as a whole is moot and shouldn't be considered by this court.
Thank you.
Thank you.
Thank you.
hear from everybody. Yeah. I'm sorry?
He said he's going to reserve it for
Okay. So you dealing with the next issue?
Your Honors, I will briefly address what the opposing counsel has just mentioned. Specifically, I understand that it has been evaded. What has been evaded in her argument is that Puerto Rico is not a state. So federalism, although it does apply to Puerto Rico, there are limits, Your Honor. Section 9 provides us that limit. Locally inapplicable must be stated and must be understood that the people of Puerto Rico have no representation in Congress, and I said this before, and I do with some force, because the people of Puerto Rico are afforded no hears. They are not allowed to vote for presidents. They have no congressmen,
that's because Puerto Rico is not a state, right?
Exactly.
Now, can Puerto Rico become a state if it wants to?
Oh, sure, Your Honor.
And it just shows them not to?
Well, Your Honor, to address that question in specific, I understand that it is the
That's a political question.
Exactly.
So we're not dealing with political questions.
Exactly. That's exactly my point. Although that it is a political question, but are the people of Puerto Rico to be applied federal statute against their will, against their desires, just because their politicians have failed to provide an answer to that precise question? People of Puerto Rico...
But didn't they provide an answer when they excluded the Native Americans and did not exclude Puerto Rico? Wouldn't that necessarily mean that the statutes, all federal criminal statutes, apply to all citizens of the United States that aren't excluded?
Sure, Your Honor. But the problem here is that we understand and respectfully disagree with that argument.
That's okay, you can do that. This is America.
We understand, Your Honor, that Congress, given this precise political...
Mr. Chief Justice, Your Honors, just to address a number of points the petitioner just made. In the First Circuit in the United States versus Rivera-Torres, this court held that most federal legislation considered by the courts has been applicable to Puerto Rico. So the position of the petitioner that this particular statute should not apply is completely contrary to what the First Circuit has ruled in the past. Particularly, there are public policy considerations when it comes to the death penalty. When we looked at another First Circuit case dealing with maritime laws that addressed Puerto Rican legislation, the court held that there is a national import when considering textual analysis to interpret the intent of Congress. The death penalty is certainly something that is of national import and something that should be applied uniformly throughout our court system. Additionally, in Mercado...
By the way, nobody disagrees with you on that point. The question again is whether the attempt to do that has been done properly here when you consider Section 9 of the PRFRA.
That's correct, Your Honor. When it's unclear, when Congress's intent is unclear, the First Circuit Court held in Mercado that the default rule is that the federal rule applies. And so if there's any confusion as to the intent of Congress, the First Circuit has said that the law should apply. Additionally,
all ambiguities are in favor of the government.
Not all ambiguities, Your Honor.
You said default if it's unclear.
But the court, that's what the First Circuit held, that the default rule is that the federal rule should apply. Taking that into consideration and the public policy considerations that weigh in our favor dealing with the death penalty and protecting victims against heinous crimes, it is our position that the federal statute should apply here as well.
Excuse me, but isn't the default rule basically not taking into consideration the unique position of Puerto Rico and its constitution and its, they abolished the death penalty in 1929 in Puerto Rico. And they affirmed that and confirmed that in the Constitution that they passed in 1952. And Congress had previously approved it. So if you're saying that all federal laws apply to Puerto Rico, even if Congress did not specifically mention it under a default rule. It's not considering anything having to do with the specific and unique characteristics of Puerto Rico and their relationship with the United States.
Well,
so how do you argue that?
Your Honor, first, the way that the government has treated Puerto Rico through jurisprudence has varied, right? In some cases, the government holds that Puerto Rico is a state and applies the same jurisprudence dealing with federal and statute superseding issues. But in other instances, the court treats Puerto Rico as a territory. And so it's our position that it's not a uniform application that Puerto Rico is treated as a state. Because it has a unique position and because it's a commonwealth, I believe that's why the First Circuit held that the default rule should be what applies to the rest of the country. And that is that the federal statute should trump the local legislation.
Countervailing that default concept, there's also the concept of lenity, which states that when there's ambiguity in a criminal statute, and I think the reason why we are here is because there's an allegation at a minimum that there is ambiguity with respect to the applicability of the FTPA to Puerto Rico. So when there's ambiguity, if you're going to err, it's better to err on the side of caution and therefore err on the side of the defendant. So why cannot, in light of the ambiguity that exists, or it seems to exist, why cannot then we apply the concept of lenity in favor of the defendant? And by the way, that goes to your public policy argument. It should be a public.
Yeah, 1 o'clock. And the bus will take you guys, you know.
you nervous? No, there's no need to be nervous.
We implore this court to hold that Puerto Rico's constitutional rejection of the death penalty renders the Federal Death Penalty Act locally inapplicable, and that where specific and fundamental Puerto Rican values are threatened, an explicit and clear statement from Congress is required to override such values.
So you're saying the Federal Death Penalty Act does not expressly include Puerto Rico?
Yes, Your Honor, it does not expressly include Puerto Rico. In fact, if we look at the legislative history of the FDPA and the text of the Federal Death Penalty Act, nothing shows that Congress even intended this act to apply to Puerto Rico.
Does anything exclude Puerto Rico?
I'm sorry, Your Honor.
Does anything in the act, and in terms of the congressional intent, exclude Puerto Rico from the applicability?
Well, Your Honor, the text of the FDPA, Congress intended the text of
I think that's a yes or no answer.
Well, there's nothing explicit, Your Honor, that Puerto Rico should be not included in the FDPA's reach. However, if we look at the exclusion that Native Americans have, we can see that Congress intended the Federal Death Penalty Act to have a substantive impact on the death penalty legislation in the country. And that impact, that substantive change, Your Honor.
Well, you mentioned American Indians. Were they excluded?
Yes, Your Honor.
Expressly?
Yes, Your Honor. They were expressly excluded. However, there is USC Section 1152 explicitly states that the general laws of the United States as to the punishment of offenses shall extend to the Indian country. Now, what that means...
What? I didn't hear the last
shall extend to the Indian country. Now, what that means, Your Honor, is that...
No, well, we're not talking about the... I was just using that as an example of how they know how to exclude. They could have excluded Puerto Rico, could they not?
Yes, Your Honor, but the only
But
reason...
did they?
No, they did not. But the only reason that Congress included the explicit exemption of the Native American tribes was because of USC Section 1152, which specifically states that punishment of offenses shall apply to the Indian country. Without that exemption of the FDPA, Your Honor, the Native American tribes would automatically be included in the FDPA's application.
Is there such an exclusion for Puerto Rico?
Well, what we have to guide us, Your Honor, is the Federal Puerto Rican Relations Act, Section 9.
So I have to go down to Puerto Rico's constitution and look at that in order to interpret the federal statute.
Well, yes and no, Your Honor. The Puerto Rican Constitution helps guide us in reaching that this interest is in fact a locally sufficient interest that meets the local inapplicability language of the Federal Puerto Rican Relations Act. However, when we're analyzing whether or not a federal statute should apply to Puerto Rico, we look at the Federal Puerto Rican Relations Act as Congress intended us to do. Now, the language of the Federal Puerto Rican Relations Act, Your Honor, incorporates locally inapplicable. And that language comes from the Foraker Act of 1900, which specifically was made to give deference to local conditions in emerging territories. Further, if we look at the Elective Governors Act of 1947, which preceded the U.S. Puerto Rican Compact of 1952, that act, Your Honor, explicitly stated by Congress that locally inapplicable was to refer to local conditions. And that was guidance for the president, who Congress gave authority to determine whether or not a federal statute was locally inapplicable to Puerto Rico.
Notwithstanding that language, would you agree or disagree that Congress has the power to enact federal laws that affect Puerto Rico?
Yes, Your Honor. Petitions such an enshrined, have such an enshrined abhorrence to capital punishment that they've actually put it in their constitution.
But I have that too, but I mean, does that mean I can just...
We respectfully request this court affirm the lower court's ruling and find that the FDPA is locally applicable.
I understand that, but tell us why we should.
For the following two reasons, Your Honor. First, Congress has the power to enact the FDPA exactly that. And the cornerstone of determining whether Congress intended for a statute, in this case the FDPA, to apply is to look at congressional intent. Congressional intent can be inferred from a variety of different sources, such as the history, other statutes, and the pervasiveness of the problem. In this case, there are two instances of note.
The first is other statutes. Section 924J is the statute that actually prescribes the death penalty in this case. The Federal Death Penalty Act is merely a method of applying the procedures, laying down the procedural safeguards that must be satisfied before the death penalty can be applied to this case or any other case. The actual statute which prescribes the death penalty is the Section 924J, and it states that it shall...
We get that, but how does Puerto Rican's Constitution that says that there shall not be a death penalty of Puerto Rican citizens crime take place in Puerto Rico, how does that affect that analysis?
It affects the analysis because it brings in that local applicability standard from the Puerto Rican Federal Relations Act.
So that's the Puerto Rican word. Oh, is that a federal word also?
That is a federal word, Your Honor.
Okay.
That comes from a federal statute.
Okay.
And Congress merely needs to comply with that by expressing their intent. And they've done so in that Section 924J, which says it applies to the states. They define state as including both the District of Columbia and the Commonwealth of Puerto Rico.
It explicitly mentions Puerto Rico?
In Section 921, which is the definitions term for this 18 U.S.C. Section 924J, it explicitly says the Commonwealth of Puerto Rico. Now, that's not the Federal Death Penalty Act, but that is the statute that prescribes a death penalty in this case. The FDPA merely lays out the procedures that the court must follow.
Let's say the procedure was intended by Congress to apply. Let's look now at the penalty itself, which is really the crux of the situation in that it goes counter to the Constitution of Puerto Rico's prohibition against the death penalty.
Yes, Your Honor. And that Puerto Rican provision in their Constitution will allow them to abolish the death penalty in their local courts. And previously it worked to abolish it overall. But Congress in the Puerto Rican Federal Relations Act, which was approved or enacted prior to the approval of the Puerto Rican Constitution and developed this compact, left in language, verbiage, which allows Congress to apply federal statutes above and beyond this local and applicability standard. It says those statutes except hereinbefore or hereinafter applied. And Congress has this power due to the territorial clause of the United States Constitution. Article 4, Section 3, Clause 2. Congress is textually committed to overseeing the territories, and in this case, the Commonwealth of Puerto Rico.
But once the compact was created, supposedly Puerto Rico was no longer a territory, but now it had a different relationship to the United States pursuant to the compact. So maybe that may not be your strongest argument with respect to applying the territorial clause to this situation. The compact really created a gap between the territorial clause and Puerto Rico because now it's a different relationship.
Yes, Your Honor. However, that compact also created this mechanism for applying federal statutes to Puerto Rico above and beyond the not being applicable, which is exactly what Congress has done in this instance. Now, petitioner may contend that it has only been applied, the FDPA has only been applied geographically. However, in the past, the courts have found that to be enough, even not looking at congressional intent and sticking with the canons of statutory interpretation, first looking at the plain language of the statute. The First Circuit in Guerrero v. Alcoa Steamship in 1956 found that a workers' compensation statute, which was locally inapplicable, was found to have been expressly applied to Puerto Rico because Congress said to all navigable waters of the United States. And since Puerto Rican lied within the navigable waters, it was said to apply clearly and explicitly. The same is true in this case. When Congress said to the United States as a whole, Puerto Rico is part of the United States.
Yeah, the other argument against that, though, is that in this situation with the navigable waters, an argument can be made that navigable waters does not equate to death penalty. So the death penalty, because it's qualitatively different than navigable waters, that would justify Congress, the application of that law, irrespective of whether Congress made it specific or not.
Yes, Your Honor, and this court has on several occasions noted that death is different, but it's different from a procedural standpoint. Procedural safeguards have to be put in place to reinforce the integrity of the system. And that is exactly what the FDPA is trying to do, set a uniform system of procedures that the courts must follow in order to safeguard the rights of all American citizens. It makes no sense for Congress to apply it specifically to Puerto Rico or specifically to California, Michigan, or Texas, because the FDPA was intended to be a uniform, across-the-board method of ensuring that the procedural safeguards that this court in the past has been so mindful of are in place. They're codified in statute, and they extend to protect all citizens of the United States.
Wouldn't it have been better if, in light of the fact that Section 9 of the compact exists, for Congress to make it explicit that it be applied to Puerto Rico instead of making us go through all of this and deciding what the intent was?
Your Honor, Congress was explicit in the actual statute which prescribes the death penalty, and then the procedural statute, which is for the entire United States as a whole.
I don't have a problem with the procedural. What I'm having a problem with the death penalty itself, the putting to death of a human being, and that's what's really going on here. Once you follow the procedure, which I don't think anyone will necessarily attack it, what the petition is attacking is that death itself as a punishment is
You may proceed.
Good afternoon, Chief Justice Perry, Your Honors, and may it please the Court. My name is Rebecca Medina, and I, along with my co-counsel Jacqueline Guzman, represent petitioner. We respectfully request that this Court hold that the Federal Death Penalty Act is not applicable to Puerto Rico for the following two reasons. First, applying the Federal Death Penalty Act without a voting representative in Congress violates petitioner's right to substantive due process. Second, applying the Federal Death Penalty Act to Puerto Rico violates the International Covenant on Civil and Political Rights.
Do you think if Congress were to enact a law making Puerto Rico pay federal taxes, that would be okay?
Your Honor, yes. In that situation, it is different than what we are dealing with here. Right now, we are dealing with a fundamental right to life.
You say Congress can pass a law allowing Puerto Rico, mandating the Puerto Ricans pay federal taxes?
Excuse me, to pay federal taxes? No, Your Honor.
That's what I meant, federal taxes.
Okay, sorry. No, they are not, Your Honor.
Well, why not?
Because this court has established that voting is a fundamental right, as stated in Bush v. Gore in the year 2000. Now, Puerto Rico does not have a representative vote in Congress as they should, and it completely goes against the consent of the governed.
So you don't think that Congress has the power to pass a federal law like it applies to all the, unfortunately, to all the other 50 states where we have to pay federal taxes? You don't think Congress has the power to make Puerto Rico pay federal taxes like it does to all the other states?
Absolutely not, Your Honor.
Why?
There are 4 million people in Puerto Rico that are unrepresented in Congress right now, Your Honor.
But isn't that true for all the other laws that have been found to be applicable to Puerto Rico? And no one has questioned them, where Puerto Ricans have not had an input into those laws?
Such as the Social Security Act.
Unfortunately, it is, Your Honors. However, that is why we are here today asking you to find that the Federal Death Penalty Act is not applicable to Puerto Rico. Now, this court has also held that death is a different punishment than any other punishment given, even a 100-year life sentence.
So it's different than wiretap?
Correct, Your Honor.
It's different than navigable waters?
Correct, Your Honor. We are asking for the federal death penalty not to be applicable since it goes against the consent of the governed. Your Honors, here, Puerto Rico deserves a right to vote on the issue prior to it being applied to the Commonwealth and taking away their citizens' right to life. Your Honors, these are U.S. citizens that we are dealing with, and they do have a voice to express as well. Now, the U.S. does give Puerto Rico a representative in Congress. However, without a voting right, they are silenced completely, Your Honors, and that is not fair to the U.S. citizens residing in Puerto Rico specifically. Furthermore, the ICCPR, the International Covenant on Civil and Political Rights, states that every citizen is supposed to be given the right to vote. Now, applying the Federal Death Penalty Act in Puerto Rico without giving their citizens this right to vote is completely contrary to what the U.S. has signed. Your Honors, in this case, these 4 million people in Puerto Rico are subject to a law that they have absolutely no say in. A law that takes away their most basic right to life, Your Honors, and this cannot happen. As a U.S. territory, they are subject to certain federal laws. However, due to the seriousness of this
What's the
issue...
territory now?
Excuse me, Commonwealth, I misspoke.
Okay.
You know, actually, you know, it's really the Estado Libre Asociado
Sí, señor.
that we translated, as quote unquote Commonwealth, but literally it means free associated state. Estado Libre Asociado is the free associated state. So in a way we're a state, but only associated. We're free, but associated.
Yes.
So we have a special relationship with the United States.
Correct.
So doesn't that really go to the applicability or non-applicability rather than this other argument of the non-representation argument?
Respectfully, no, Your Honor. That actually enhances our argument that since we are like a state, we should be afforded under Amendment 14, Section 2 of the U.S. Constitution a representative vote in Congress. Now, since we have been treated as a state, and we are state-like in many ways, Puerto Rico deserves the right to vote prior to applying a federal death penalty act.
Can Puerto Rico opt in or opt out of being a state?
Can they?
Yes.
No, they cannot, Your Honor. Now, we do ask that they gain the representative vote. If not, the Federal Death Penalty Act should be held inapplicable to Puerto Rico. Thank you.
Thank you very much.
Oh, yeah.
You ready to proceed?
Yes, Your Honor. May I please court?
You may.
I'm Darren Chambers, and I also represent the respondent in the United States. This case is about the express authority under the Constitution. We respectfully request that this court affirm the First Circuit's decision for the following reasons.
But let me ask, are you arguing on the issue of the Fifth Amendment, whether it's violative or substantive due process?
Yes, Your Honor.
Okay.
Yes. For the following reasons, there is no due process violation. First, that Congress has express authority to legislate over the territories.
And I'm sorry to interrupt you, but I need to know these answers. The Puerto Ricans vote in Congress.
Puerto Ricans have a resident commissioner, but they do not have members of Congress, no, voting members.
They vote?
No.
Okay, so the answer is no. But yet Congress makes decisions that affect Puerto Ricans, although Puerto Ricans do not have input into that decision, correct?
Yes, sir.
Okay. I asked the question before on taxation. Does Congress have the power to impose federal taxes on the people of Puerto Rico?
If Congress made legislation to...
Just like passes the IRS as it affects us, that we have to pay federal taxes come April 15. Well, some of you do, I don't, but that's another issue. They're after me now. No, I'm only kidding. But seriously, the Congress has made a decision to have the income tax, correct?
Yes, sir.
Can it extend it out to Puerto Rico?
If Congress made legislation explicit
Yes.
to Puerto Rico, yes.
Won't Puerto Rico then have a Puerto Rican Tea Party over there? You know why I say Puerto Rican Tea Party? What was the reason why you had the Boston Tea Party?
I was taxation without representation.
Now, that's taxation without representation. Isn't this matation without representation?
I'm sorry, Your Honor?
Isn't this matation without representation? Matation is a word that I've taken from Spanish, matar, to kill. So I anglicized it into matation. So matation without representation would be akin, I would submit, or for you to rebut, that it would be akin to taxation without representation.
In other words, killing without representation is equal to taxation.
Yes, Your Honor, but still under Article 4 Territories Clause, Congress has the right to legislate.
Territorial, but I thought that we had eviscerated some of that territorial language by the fact that it became a commonwealth through the compact. So it may not be, the territorial analysis may not be applicable here when we no longer have that relationship, but rather a commonwealth compact relationship.
Your Honor, then Article 4 also states how states become admission of new states. Puerto Rico has not been admitted as.
Puerto Rico is not a state. They have a constitutional provision that strictly prohibits death sentence.
Yes, Your Honor, as does Michigan in their constitution. Again, the standard that this court uses is one of a national standard, looking at not only the states, but the Commonwealth and the territories.
Puerto Rico is really a part of the United States, although it's not a state.
Although it's not a state, yes, Your Honor, it is a part of the United States, and it's looked to as a whole to determine if it offends those the decencies and sensibilities of the people, Your Honor. And this court has stated that it does not.
Excuse me. Didn't Congress give up a little bit of its sovereignty when it allowed itself to come into an agreement with Puerto Rico under the Federal Relations Act?
Yes.
Did they give up a little bit of their of the United States, I mean?
Yes, sir. But it still made. It still
in terms of the business of locally inapplicable.
Yes, Your Honor. But it still maintains the federal reach that it has. It still maintains that if federal laws are violated within Puerto Rico, that they're seen to in federal courts, Your Honor. So it did not give up that authority. Again, the Fourth Circuit and the Second Circuit have also stated that the Federal Death Penalty Act does not violate due process. It goes again to the legislature trying to make a universal system to get rid of the arbitrariness. What the FDPA does is it does protect petitioners' due process. It gives a standard that's used throughout the United States reach of how to apply the death penalty. It protects against arbitrariness how the death penalty is applied across the United States. Also, Your Honor,
you have a minute.
It's used. It's also used against foreigners who have no representation. If someone who's not from this country comes here and violates a federal crime, they face the same death penalty that someone from Florida does, that someone from Puerto Rico does, and again, they do not have representation either. They've never had representation, and they're not even United States citizens. It's applied systematically and alike through all areas of reach of the United States. Your Honor, for these reasons, we respectfully request that this court affirm the First Circuit's decision.
Thank you very much.
Thank you.
I think this concludes the arguments. Do you rebut?
Oh, that's right.
Then you flip a coin.
Hi, Your Honors. Just one point on rebuttal. Respondents stated that this application of the Federal Death Penalty Act does not shock the conscience and that it is a national standard. However, this court has held that shocking the conscience looks to conduct that is brutal, demeaning, and harmful in order to determine what shocks the conscience. And it is brutal in the sense that we are taking away a U.S. citizen's life without
I get that. What I don't get is it shocks the conscience in Puerto Rico, but not in Florida. I mean, why is it different? Who really wants to die?
Your Honor, it shocks the decencies of civilized conduct.
So Puerto Rico is civilized and everybody else is.
No, everybody is civilized, and it shocks.
It shocks everybody's conscience. Okay.
Correct, Your Honor.
All right.
Thank you.
So, all right.
You know, I guess you may be seated. You all did a fantastic job. I mean, this has been a real pleasure for us. It's going to be hard for us to decide who the winners are, but you know, everybody can't win, right? That's the nature of the profession.
There are no losers.
In this case, there are no losers, but you guys did a great job. And but only one team can be picked. So unfortunately, when you get in this adversarial game, you know, one side 50%, it's about all you get. Other 50%, you don't get. We haven't determined who that is yet. But good luck to all of you.
Thank you.
Good morning, Mr. Chief Justice.
Did you say good morning?
Good afternoon.
Oh,
Sorry.
okay.
Good afternoon, Mr. Chief Justice. May it please the court. My name is Alicia Torres, and along with my co-counsel, we represent the defendant, Mr. Guerrero. At this time, the appellant requests 1 minute for rebuttal.
How many?
1 minute.
1 minute, okay.
Thank you.
So you represent the appellant, Mr. Pujols?
Yeah, Mr. Pujols, yes.
Okay.
I will be discussing the standing issue and the locally inapplicable issue, and my co-counsel will be discussing the substantive due process issue. An individual has standing under the International Covenant on Civil and Political Rights when Congress enacts a separate legislation that is reflective of the ICCPR. Here, the federal death penalty is related back to the ICCPR. Under Article 6 of the ICCPR, there's an express prohibition on capital punishment for anything other than a heinous crime. And here, the federal death penalty prescribes capital punishment for various crimes. However, a defendant still has to prove that he has standing under the Federal Death Penalty Act. For us, he has imminent harm caused by the respondent in this case, and only a favorable redress by this court will solve that. He is facing the death penalty. He has been harmed in that way. He feels the imminent harm. So we feel that under the Federal Death Penalty Act, he does have standing, and therefore he can bring his claim under the International Covenant of Civil and Political Rights. However, if the courts do not feel that our client has standing under the ICCPR, we still find that the Federal Death Penalty Act is locally inapplicable to Puerto Rico.
That's what you think?
Yes.
You said you find it.
Yes. If understanding if he doesn't have it under the ICCPR, we still feel like it's locally inapplicable under the Federal Relations Act because the Puerto Rican Constitution expressly prohibits. In order for federal legislation to be locally inapplicable, it must be irreconcilable with the Puerto Rican Constitution. It must conflict in some way. Here, Article 2, Section 7 of the Puerto Rican Constitution expressly prohibits capital punishment. Notwithstanding Congress's failure to actually expressly include Puerto Rico in the death penalty, there's no congressional intent that shows that they intended to have the breadth of the federal death penalty over the island either. Congress ratified the Puerto Rican Constitution after several amendments. At least 3 times they saw the Puerto Rican Constitution, and not once did they strike the prohibition.
Now, didn't Congress say it's okay internally for Puerto Rico not to establish a death penalty?
Yes, Your Honor, they did allow
But did that inclusion preclude the federal system from having a death sentence for all citizens?
Only in the sense of Puerto Rico, and I think here it's that Congress did not they intended for this federal death penalty to not be applied to Puerto Rico because they didn't include it in the federal death penalty.
Did they exclude it?
They didn't expressly exclude it, but
did they exclude anyone?
They excluded the Native American tribes.
Okay, so they excluded the Native American tribes, but they forgot to exclude Puerto Rico.
Well, I think that the Native American tribes are a fundamentally different dual sovereignty under.
And Puerto Rico is not sovereign.
It is sovereign, but it's a different relationship between the Native American tribes and Puerto Rico with the compact.
But isn't exclusion?
I'm sorry?
Isn't exclusion?
Well, you would also have to still look at the actual congressional intent. So even though they didn't expressly exclude them from the act, I still believe that they...
Well, what about the default clause? Does that include it because they weren't excluded?
Sorry, can you do that? So it should have
The intent was not to exclude Puerto Rico, wasn't it?
Well, if you look at the legislative history, it would appear that that's not it. It would have, the legislative history would have excluded it because nothing states within it that they wanted to include the breadth of the Federal Death Penalty
So
Act.
is anything in the legislative history that said Puerto Rico is excluded?
I'm sorry?
Is there anything in the legislative history that indicates that Puerto Rico is excluded from the Federal Death Penalty Act?
No, Your Honor, but there's nothing that expressly in the history.
What history should we look at then?
Well, I think you have to look at the relationship between the Puerto Rican Constitution and the Federal Death Penalty Act and the...
Well, what about Michigan's Constitution? Should we look at that?
Well, I think that there's a difference between the relationship between the states and the Commonwealth of Puerto Rico. They have a compact. They've enacted their separate constitution. They've, the Congress has ratified the Puerto Rico's constitution without striking the death penalty.
In Puerto Rico for Puerto Rico's government.
Correct.
But not for the federal government.
Well, I believe that if they would have wanted to include Puerto Rico, they would have done so, since they're aware of their moral repugnance of Puerto Rico in they're aware of the moral repugnancy to the death penalty that the islanders feel.
Of course, the counter argument to that is that in excluding the Native Americans and not also mentioning Puerto Rico, there is an extremely strong inference that can be drawn that the intent was not to exclude Puerto Rico, because it would have been so easy to what they said with respect to the Native Americans. It could have been said about the Puerto Ricans too. The failure to do so, again I submit, paves the way for a very strong inference that the intent was not to exclude Puerto Rico.
And we do
but that's a good argument though.
Well, we do understand that, and I just want to bring your attention to Colon v. Conti Perez, where they expressly included the District of Columbia for the Voters Protection Act, and they didn't include Puerto Rico, which again they could have if they felt that it went to them, but the Supreme Court felt that because there was no congressional intent there and they didn't expressly include them, that act also did not go to the Puerto Ricans. So I think it could be argued the same way. Thank you.
I think your time's up.
Very well.
Very good. Thank you. You may proceed.
Good afternoon, Mr. Chief Justice. May it please the Board. My name is Jan Peña and I represent the United States of America. As a respondent, I think that it is important to do a historical page 680 when the Congress, including Luis Muñoz Marin, the Governor and Commissioner Resident Fernando Cicerne, but they have cleared that the plenary powers of the Congress could be and can be applied in Puerto Rico. One of the arguments of the petitioner is also that under the Article 2, Section 7 of the Puerto Rico Constitution, the death penalty, the Federal Death Penalty Act cannot be applied to the U.S. citizens residents in Puerto Rico. But it's a question that the petitioner didn't answer. Would be the Article 2, Section 7 of the Puerto Rico Constitution be preempted by the Federal Death Penalty Act? I will answer you. The intention by the interpretation of the U.S. Supreme Court when they established what is the interpretation of the Congress is clearly the national security of our citizens. It's clearly when I, as a U.S. citizen resident in Puerto Rico, the criminality, the insecurity in our island, and this is a kind of provision. This is a kind of law.
Counselor, but no one is arguing with you the other way. No one is arguing that the federal government apparently does have, Congress has the power to enact laws that apply to Puerto Rico. I think everyone agrees with that. I think the issue here is whether this particular law is one because of Section 9 of the PRFRA, whether Section 9 really contemplated this type of law being applicable to Puerto Rico. That's really the question. You know, the security of Puerto Rico is bad, and as citizens we should not fight the attempts by Congress to fight that criminality in Puerto Rico. Question is, are they doing it the proper way? Are they doing it in a legal way that does not violate Section 9 of the compact? That's really the issue.
Thank you for your question, Justice. We cannot forbid what is our constitutional framework. The Congress, under also the Treaty of Paris in 1998, clearly in the last paragraph of the Article 9 of this treaty, the Spain said, and I quote, that all the inhabitants, they cede the territories to the United States under the plenary power of the Congress. And the Congress today and tomorrow will be and have the power to extend and apply all the laws that they intend, that they think that are important.
But wasn't that affected by the compact?
It's affected under the compact because
I'm sorry, prior to the compact, I think no one would argue against that. But then once the compact comes into existence, it changed somewhat the relationship between Puerto Rico and the United States.
Under United States versus Quiñones, Justice, the First District Court established that when the Congress are agree and approve the Puerto Rico Constitution after the 82 Congress, they don't have the intention to change the relations and the power of the Congress. They just provide the power to the local government and to Puerto Rico to ordain and organize a local government. But it is not the same thing to say that then that the U.S. Congress cede his powers to the territory, because the Article 4, Section 3, Clause 2 clearly established that all the territories and property all belong the plenary powers of Congress, and Puerto Rico is a territory and is under the plenary powers before and after the 1952 Constitution approval.
You would not hear any disagreement from me on that point. But the thing is, and I throw it to you, under the territorial clause, Puerto Rico had and prior to the compact, Puerto Rico had a particular relationship. But once the compact comes into being, the territorial clause is not as
was to cede a Puerto Rico local government, cede powers to organize the local government, but because how I said before, one Congress cannot force another Congress to approve a law, and the 82 Congress intention, when we see the hearings in the pages 456 and so the Congress has the power and also amend the Puerto Rico Constitution because they know that they have the power to do it.
Well,
after
isn't it really that Puerto Rico has the right to establish the penalties under Puerto Rico's law?
Yes.
But they don't have the ability to impose penalties or lack of thereof on the federal law. But they are different. They're on different tracks. Federal law is on this track, Puerto Rico law is on this track. Puerto Rico cannot dictate the penalties under, but it can dictate, and that's the autonomy that Congress gave Puerto Rico.
But this is not the first.
That was a friendly question.
Thank you. This is not the first time that the Congress approved a law with a representation, with the participation of Puerto Rico. We can see it in Davila versus Lockheed Martin, when the Congress directly and with a representation of Puerto Ricans approved the Defense Base Act. After that, in United States versus Suarez, the Congress approved the Clean Water Act, and before that, when we see Moreno versus Rios, the Congress and the Supreme Court opinion clearly says that Puerto Rico has a different has a relation with the United States and has a local government establishing powers, but they never cede. The Congress never cede their powers to the territories or to other, or their plenary powers over the Constitution. But the U.S. Supreme Court also, in Down versus Bigelow and Barzal versus people of Puerto Rico, sustained that Puerto Rico is under the territorial clause.
So you're arguing then that it appears as though Congress has the unfettered, unlimited power to pass laws over Puerto Rico?
Yes, this is my opinion.
Does Puerto Rico, do they pay federal taxes?
Well, we pay it we are paying the Social Security and other laws. And the Puerto Ricans that reside in the United States also pay that.
Let me ask you this question.
That's the federal government.
Yes.
Workers of the federal government.
But we in Puerto Rico, we can pay the Social Security, and it's a kind of taxation.
Let me ask you, was making the colonies and the colonists pay taxes. That brought up, I don't know if you guys may be too young to remember when it happened, but there was a Boston Tea Party
Yes.
in Massachusetts.
Were you there?
I was there. I was very young at that time, though. And what happened was, it was revolt against taxation without representation. Now let me finish. If we allow now, I'll finish this sentence quick. If we allow now for FDPA to come, then cannot the argument be made that this is matation without representation?
I can answer the question.
Killing,
Yeah, you bet.
killing, matation is my Puerto Rican word. Matation without representation. Just like it was taxation without representation. Isn't that the case here?
No, this is not the same. This is not the same thing, Justice, because the historic comparison between Puerto Rico and Canada is different, because the kind of Commonwealth that the United Kingdom approves in Canada was very, very different than the Commonwealth that the Congress approved in Puerto Rico. And the taxation without representation was an argument that during the Public Law 600 operation, the governor, Luis Muñoz Marin and Antonio Fernández Isern, they are agreed that they have a Commonwealth to attend the local governing matters, but they have a representation with a vote, and the people of Puerto Rico ratified this agree when his vote during the voting process of the Public Law 600. This is my argument. Thank you.
Thank you.
Very good. You may proceed.
Good afternoon, Mr. Chief Justice, and may it please the court. My name is Ashley Aguiar, and I too represent Mr. Pujols in this matter. I will be discussing whether sentencing Mr. Pujols to the death penalty violates his substantive due process. Now here, Your Honors, when we look to determine what violates substantive due process, we have to determine whether federal action shocks the conscience. And here, sentencing Mr. Pujols to the federal death penalty while denying him the right to vote in Congress shocks the conscience. Now, the standard for shocking the conscience is egregiousness. Now, courts must look on a case-by-case basis when we want to determine what is egregious. Here, because Mr. Pujols does not have the right to vote in Congress, sentencing him to death under that Congress shocks the conscience and is egregious. For example, in Rivera versus Puerto Rico, the District Court of Puerto Rico held...
What constitutes egregiousness?
I'm sorry, Your
The
Honor?
killing is what constitutes something being egregious?
Well, egregious, there is no bright line definition for egregiousness. Courts have to look at it on a case-by-case basis, but typically, the courts will find that federal action is egregious when it is so brutal or offensive as to violate traditional notions of fair play or decency.
So,
So what constitutes a violation of traditional norms of decency here?
Well, here, Your Honor, because Mr. Pujols does not have the opportunity or the ability to vote in Congress.
So it's the lack of voting, not the death itself, that is egregious?
No, Your Honor.
Or a combination of both?
It's the inability to vote coupled with the application of the federal death penalty here that is egregious.
1 + 2 = 3, meaning the death plus the lack of in of itself is egregious.
Yes, Your Honor. In that circumstance, it was held to be egregious.
I'd rather be sexually harassed than killed.
Well, exactly, Your Honor. And that's why sentencing Mr. Pujols to the death penalty here is so egregious, because he did not have consent in enacting the federal death penalty. And it is helpful if we look at things that are not egregious, as there is a sharp distinction between what courts have held to be not egregious and what we have here. For example, in Cruz versus Puerto Rican Power Authority, there an electrical worker was denied a promotion and his boss did not recognize his due pay grade. The courts there held that that was not enough to be egregious or shocking the conscience because it simply did not violate traditional notions of decency. Similarly, in Pagan versus Calderon...
And neither is death, by the way, according to you.
I'm sorry, Your Honor?
Neither is death egregious to shock the conscience.
Well, Your Honor, death is inherently different than many other things.
But not egregious.
Normally, typically speaking, Your Honor, under the federal death penalty, sentencing a criminal defendant to the death penalty is typically not egregious in the United States. However, because Puerto Rico did not have the adequate representation in Congress.
But isn't Puerto Rico part of the United States?
Puerto Rico has a unique relationship with the United States, Your Honor.
As what?
A unique relationship with the United States.
Okay.
In
But
that,
death is unique and different, right?
yes, Your Honor.
And is that the connection? Puerto
Well,
Rico is unique and death is different.
well, it's not just that Puerto Rico is unique, although it is. It's the relationship between Puerto Rico and the United States. Because Puerto Ricans cannot vote in Congress, that's what makes the relationship unique. And applying the death penalty here, given that lack of voting, is also what makes the situation unique.
In your situation with respect to the sexual harassment case,
Yes.
if the sexual harassment case had been a federal law, but Puerto Ricans did not have the right to pass that law, that federal law, would that have made it even more egregious, or it doesn't matter?
Well, perhaps, Your Honor, it may have made it more egregious. However, that conduct was held to be egregious either way.
But the fact that it was a local law applied to Puerto Rico.
Yes.
It was not a federal law.
No, Your Honor, it was not a federal law in that specific case. But what we're looking at here is the conduct. So we're looking at Puerto Ricans not being able to vote and then sentencing a Puerto Rican to the federal death penalty. That conduct is what is egregious.
But the issue about voting was not present in the sexual harassment case and in the labor case.
Right, Your Honor.
So that had nothing to do with the case, lack of voting.
Exactly. In those cases, the conduct was not held to be egregious. However, if we look at our case in contrast, because Mr. Pujols may be put to death under a statute that he had no representation in enacting, that is egregious. It violates traditional notions of decency that someone can have their life taken from them under a statute that they had no say in creating or enacting.
Excuse me.
Yes,
But
Your
it's
Honor.
only the Constitution of Puerto Rico that has that prohibition.
Well,
So what if they executed him in Atlanta, in federal prison,
Your Honor,
and not in Puerto Rico?
Your Honor, then perhaps.
Would that be respectful
Well, Your Honor,
of the laws and Constitution of Puerto Rico if they didn't execute him over there, but they transported him to Atlanta, Georgia, let's say, and federal penitentiary there, and just execute him?
well, Puerto Ricans are protected by their constitution no matter where they are.
So you're saying that...
So it's not a physical thing.
So you're saying the Puerto Ricans that live and reside in the United States can't be executed because of the Puerto Rican Constitution?
Your Honor, and I think to answer maybe your questions collectively, sentencing someone in...
I didn't hear you. What did you say?
To answer your questions collectively.
Oh.
So...
I don't think you can do it collectively. Answer his first and then answer mine.
Okay. So, no, Your Honor, it's not that the Constitution, I think if I understand your question correctly, it's not that it's a physical thing. What we're looking at here is taking someone's life when under their own constitution, that is protected. So taking their life under a federal statute that they had no say in enacting. And I think if we look at the fact that juries have, Your Honor, may I please
finish?
Thank you.
Because you have to answer my question.
Right. So if we look at the juries in Puerto Rico, the United States government has sought the death penalty on 6 defendants. Yet in the face of overwhelming evidence, Puerto Rican juries have systematically acquitted those defendants. So even if we were to take a defendant to another state and execute them there, even if that were to be constitutional, it violates the deeply held sentiment in Puerto Rico that the death penalty simply should not exist.
I pass on.
Okay. Thank you, Your Honor.
Thank you.
Good afternoon again, Justice. We are at the issue of this case is if the Federal Death Penalty Act is locally inapplicable. During my first presentation, I maintained and defend two main arguments. First, that the Congress has plenary powers over Puerto Rico before and after the approval of the 1952 Constitution. I speak about the Treaty of Paris that the petitioner didn't break this argument Also, I speak about the insular case of Down versus Bidwell, Barsag versus People has the state maintained the argument that were presented before the United States Constitution. But after I finish my argument, I want to clarify something.
I think you have a minute.
Oh, but let me check the conscience.
said
The Congress clearly in Augusta versus Martinez, Sanchez versus Quiñones, Justice Lynch says, and permit a quote, it cannot shock the conscience of court to apply to Puerto Rico is intended by Congress a federal penalty for a federal crime which Congress has applied to the 50 states. The petitioner didn't answer our question, and we're waiting for that.
But it could be argued that Lynch, just because he says it doesn't mean he's right, if he is ignoring what the petitioner would like to argue, that those words are very strong words. So he has simply, I'm telling you, the argument can be made. I'm not saying that it is. That those words still, that not locally applicable, those words are powerful words, and I think that's really the crux. Why we all here is the crux of those words in Section 9 of the Compact.
But this is the actual, this is the actual.
Excellent answer.
Thank you.
That was rhetorical.
Okay.
Yeah.
Thank you.
No, yeah.
One quick point on rebuttal, if I may, Your Honors.
One quick point?
One quick point.
Okay.
Congress cannot use the judicial system to correct their mistakes. The Puerto Rican Federal Relations Act says that laws that are locally inapplicable shall not apply to Puerto Rico. Your Honors, we are simply asking in this narrow issue of Mr. Pujols and his lack of representation in Congress, sentencing him to the death penalty, this specific narrow issue, Congress implicitly and explicitly did not intend for Puerto Ricans to be sentenced to death under the Federal Death Penalty Act. Thank you.
Thank you.
Thank you.
So, is that it? Ready?
Honors, Glenda Santiago, counsel for the petitioner, Enrique Guerra Pujol. May it please the court?
You may proceed.
This case is about life. The absolute respect for life, even the life of those who are accused of committing heinous crimes. It is also of utmost importance because it's about the viability of the relationship between Puerto Rico and the United States in 2014. We asked the court to reverse the lower court. States entered into a relationship with Puerto Rico.
Is that the compact?
That is the compact
Gotcha.
that was established between both. They granted Puerto Ricans the ability to draft their constitution. They also had the ability to revise that constitution. They made changes to Section 5, which dealt with public education, and made sure that it was limited to elementary education.
Now, did this compact not allow Puerto Rico to organize internally, to set up their own government, their own rules and regulations, to regulate themselves as it relates to Puerto Rico, but not to this other track, the federal track, that flies above? Now, just who determines that? Who makes that determination?
That determination is made by Congress's intent.
By Congress, okay. Now, does Congress have to explicitly preclude Puerto Rico from being applicable to federal statutes?
The applicability of federal law has been the determination of which laws are applicable in Puerto Rico which federal laws are applicable in Puerto Rico to look at societal, economic, and legislative conditions.
Well, it's a factor to consider, as I said, but what I'm saying is not necessarily dispositive of the issue before us.
The Federal Death Penalty Act does not expressly exclude Puerto Rico. We understand that.
But what about the criminal act itself that was violated? Did that not expressly include Puerto Rico?
That criminal act says that it applies to the states. An argument has been made that in the definitions, when is referred to as la
Was the
tómbola.
death penalty imposed on Mr. Pujols?
The death penalty was, by the First Circuit determined that the death penalty is applicable in Puerto Rico. What we're saying is that we find that decision was erred.
I think his question is, did the jury in the Pujols case recommend the death penalty?
We don't have the details to that. I can tell you that Acosta Martinez, the death penalty was applied, and as a punishment to the federal government, the people in that jury decided to acquit both defendants.
Okay. Go ahead.
Yeah, Pujols, I think the procedural posture that is before us in Pujols, it was a motion made to the district court dismissing the action because of inapplicability of the law, and that decision of the district court dismissing the action has come to the to us.
Okay.
As we were talking about congressional intent, we see that in Congress's actions, when they revised Puerto Rico's constitution, they made determinations as to what could or could not be on that constitution, keeping in mind the federal regulations. The death penalty will not exist in Puerto Rico. The people of Puerto Rico are not willing to impose it.
I hear what you're saying about, now, had they said, all right, Puerto Rico, and your local laws, you have to impose the death sentence. They didn't say that, they left that intact, that you did not have to under your local law. But that does not necessarily transfer to federal laws, does it?
No, it doesn't, but
couldn't other people say, well, Puerto Rico can't die under this law, why should we die under this law?
well, we're asking you today to determine it for Puerto Rico.
But your answer to Justice Perry would be as follows. We do not die because we do not vote to die. You, in the United States, you can die because you vote to die.
Not necessarily.
There are
I don't know anybody that's been sentenced to death voted to die.
The Congress, the Tea Party people.
Tea Party, yeah.
Can I have a minute?
Oh, that's not. But that's
Can I have a minute to finish my
You
Go ahead.
We're asking that the federal death penalty not be applicable to Puerto Rico. One, because it goes against the Puerto Rican Constitution, with Congress allowed. Two, because it's a due process violation. We are not allowed to vote. And that is in essence part of what the Republican government of the United States was established.
But isn't the jury system the essence of government, of the people, by the people, and for the people? And the jury makes a determination. And you said that the jurors in Puerto Rico just simply nullified that. So why are we arguing this?
Because the juries in Puerto Rico in federal cases are different and are limited. Not every
You have different Puerto Ricans in federal cases?
Well, Puerto Ricans in Puerto Rico, not all speak English, which you're required to speak in order to be part of those juries. Usually those are people in higher class, they've been educated differently, and essentially
They don't mind dying.
They're not peers. They're not peers.
Okay. Thank you.
May I ask, how many of the three arguments are you doing personally?
I'm doing the first argument, Your Honor.
The first
that-
one?
Yes, that
Which
the
is?
statute is locally applicable to Puerto Rico.
Okay, very well, thank you.
Oh, you may proceed.
May I proceed? Okay, thank you. Good afternoon, Your Honors, Chief Justice, may it please the court. My name is Jacqueline Guzman, and I, along with my co-counsel Rebecca Medina, represent respondent in this. Your Honor, is not from the perspective of, it's not the local perspective of Puerto Rico. It's the congressional intent for the statute to apply. And here, that congressional intent for the statute to apply can be
So
seen.
contrary to what your counterpart said, Puerto Rico cannot veto federal law.
Your Honor, no, this court and no lower court has ever found Puerto Rico to be able to unilaterally exempt federal laws from Puerto Rico merely because of a constitutional conflict.
Is the reverse true?
Your Honor, the presumption in Justin Mercado versus the Commonwealth does create a presumption that federal laws do apply to Puerto Rico unless Congress explicitly states otherwise. Now, the case, for example, Your Honor, in United States versus Quiñones, that involved a blatant conflict of a federal statute with the Puerto Rico's constitutional ban on wiretapping. In that particular case, it was found to apply regardless of Puerto Rico's constitutional ban.
Well, not only that, but what I've been garnering here is that there have been some statutes created by Congress that explicitly state that it applies to Puerto Rico. Some statutes that do not say whether it applies explicitly or not to Puerto Rico, yet it has been found to apply to Puerto Rico. And then there has been some statutes that do not say whether it explicitly applies or not explicitly apply, but have been found not to apply to Puerto Rico. So it's going every which way.
Yes, Your Honor, there is some confusion.
So how are we to clear that confusion now when we issue this monumental decision?
Well, Your Honor, if we look to the Justice of the Commonwealth of Puerto Rico in 2007 actually testified regarding Puerto Rico's applicability of the Death Penalty Act. Now, in that particular Senate hearing, that representative made clear that Puerto Rico had a unwavering and broadly accepted rejection of the death penalty. Yet, since 2007, Congress has not added an explicit exemption for Puerto Rico. In fact, Congress, and did so through the text, through the statutory scheme, and also since 2007.
You mean apply to Puerto Rico, you mean?
Yes, Your Honor, misspoke. Applying to Puerto Rico. Congress has known since 2007, even arguendo if we accept petitioner's contention, that Congress did not anticipate or think about necessarily how this would affect Puerto Rico. We can say that since 2007, Congress has known that Puerto Rico has an entrenched constitutional abhorrence to the death penalty, yet they still have not exempted Puerto Rico. And that, Your Honor, is very telling considering the special relationship that Puerto Rico has to the United States. Now, the United States and Puerto Rico both entered into the U.S.-Puerto Rican Compact. And
So are you saying then that even if it were to be established that Congress intended for the FTPA to apply to Puerto Rico, that there is no challenging Congress's power to do so?
No, Your Honor, there is no challenge to do so, as the United States maintains plenary powers over Puerto Rico, and the people of Puerto Rico agreed in the U.S.-Puerto Rican Compact, which included the Federal Puerto Rican Relations Act, to have all federal statutes apply.
So what weight do we give to the language about the local inapplicable, not locally inapplicable?
Your Honor, the First Circuit got it right in that case, and the First Circuit said that refers to congressional intent for it to apply to Puerto Rico. But we don't even have to go to that second prong, Your Honor.
Because you're saying that the intent is clear, because the intent is clear, we don't have to go to the second prong. So what I'm saying, assuming that's correct, you're saying that then means we do not need to go into that phrase, locally inapplicable.
No, Your Honor, we do not need to go into a locally inapplicable.
So Congress is the one who's determining whether it's locally inapplicable, not Puerto Rico.
I'm sorry, Your Honor.
So Congress is determining whether it's locally inapplicable, not Puerto Rico.
Correct, Your Honor. And that is the agreement that was signed that was agreed to by both parties through the U.S.-Puerto Rican
Because I think
Compact.
you would agree with me that key to resolution of this issue is to determine who is responsible for making the locally inapplicable determination.
Yes, Your Honor.
Okay, I believe your time is up.
Oh, okay. Thank you very much.
Thank you.
Yep. Good.
Constitutional principles. Your Honors, upon acquiring Puerto Rico as a territory and further as they became a commonwealth, we have always maintained a plenary constitutional authority over Puerto Rico. Now, Your Honors, in passing the Federal Death Penalty Act, Congress was merely acting within their power to apply this to Puerto Rico. Your Honors, Puerto Rico does not gain a special exemption merely because their constitution states otherwise. Here, since we have that broad plenary authority over Puerto Rico, it is fair that Congress does apply this to them. Now, Your Honors, the contention that just because we are dealing with death means that they should receive a voting representative in Congress is false. Now, in this instance, the content of the policy in which we are applying does not equate to a violation of substantive due process. They do have a representative in Congress who speaks on their behalf, and their voice is noted in Congress as well. Furthermore,
Does he have a vote? In other words, if there's a tie, can he put in the tiebreaker?
no, Your Honor, he
If he's
cannot.
the vice president, he did.
When he becomes vice president, can he do it then?
Your Honors, in this instance, we look to the Constitution to see who gains the representative vote in Congress. Now, the Constitution clearly lays out that the states will gain a voting representative in Congress. However, the key factor is that Puerto Rico is not a state.
Really?
Yes, Your Honor, Puerto Rico is a commonwealth. And
All
in
this time I thought Puerto Rico was a state.
Your Honor, as a commonwealth, they do not gain the representative vote under the Constitution. Now, this court has held in the past that there is a hesitation in expanding the definition of substantive due process in order to expand it. Now, Your Honors, here, rather than expanding the thought of the concept of substantive due process, we should maintain the constitutional principles that we do follow. In this instance, the theory that not having a constitutional representative in Congress, a voting representative in Congress, does not shock the conscience. First, this court has never held that a legislation shocks the conscience. This court has only applied fundamental fundamental constitutional principles that we are asking you to uphold. Just because it is the death penalty does not give Puerto Rico a right to have a representative vote in Congress. There are certain, in addition, there is a jury who would decide at the end whether or not the citizen will be subject to the death penalty, excuse me. Now, with this death penalty, they are receiving substantive due process since they gain the jury to determine whether or not it does apply. For these reasons, we ask this court to uphold the decision and find that the Federal Death Penalty Act does apply to Puerto Rico. Thank you.
Thank you. Rebuttal? How long? 3 minutes? You may proceed.
Council Freddy Hernandez for Interamericana University. Your Honors, the sister council referred to the exclusion of the Indians, Americans of the Federal Death Penalty Act, and we'd like to state that Indians have they vote in the United States. Puerto Rican, we don't have that right yet. So there's a right explain difference right there about the difference of both cultures. We also would like to express quickly to the argument of U.S. versus Quiñones, the Wiretap Act. We think we think that the Wiretap Act was applied as an evidentiary issue. On the discussion before the enactment of Puerto Rican Constitution, Congress in Puerto Rico thought that this could happen. They thought that eventually the wiretapping could be applied, but on this case, however, we're talking about the right of living. We're talking about death penalty. It's not the same thing that's happening in this case. Also, the ICCPR Council also established that it was not self-executing. We do understand that it was not, but under that pact, Congress also was obliged to legislate in order to enact the different process for this to happen. We would like to not to only argue the rule of law, but help to change it and developing into the reality of Puerto Rico. Thank you.
Very good. That's it, right?
All right.
All right, we'll take a short recess.
Yeah, absolutely. But
the modulation. Right.
Ay, caramba.
Go take a break. And if you needed another one, too.
Yeah, I a little bit. I like it.
proceed? Yes. Who goes first? And which side are you arguing?
We're the petitioners.
Petitioner. That's the defendant, right?
Which of the three arguments, or how many?
So I'll be addressing the first and third question, and my co-counsel will be addressing the second question.
Okay. So tell me which ones those are.
So I'll be addressing the local inapplicability and the violation of the ICCPR.
Proceed.
Mr. Chief Justice, Your Honors, good evening. May it please the Court. My name is Zelma Myrie, and I'm joined by my co-counsel, Karen O'Neill Ocasio. The first issue is whether the United States can enforce a federal statute in Puerto Rico, even when Congress has not expressed the intent to do so. And second, even if such an intent was expressed, whether or not that statute violates the International Covenant for Civil and Political Rights. The answer to both of those questions is a resounding no. First, the Federal Death Penalty Act does not apply to Puerto Rico because Congress has not expressed the intent for it to do so.
But what about the argument that all federal statutes are applicable to Puerto Rico unless Congress says it's not?
I'm sorry, can you rephrase the question, Your Honor? I'm not sure I understand.
What about the argument that Congress intended for all federal criminal statutes, code, to be applicable to Puerto Rico unless it accepts Puerto Rico from the statute?
Okay, Your Honor, in the I believe you're referencing the Puerto Rican Federal Relations Act, which the explicit language there says that it will be the statute will apply unless it's locally inapplicable. It's our position that the reason why Congress included that.
Who determines what is locally inapplicable?
Okay, Your Honor, in the First Circuit, Rivera-Torres, not Rivera-Torres, I'm sorry, in Cordova v. Chase Manhattan, then Judge Breyer. So, for the purposes of applying the Federal Death Penalty Act, we feel that the special relationship that Puerto Rico shares with the United States makes this locally inapplicable. There's a policy, there are two important reasons why this should not be applied here. First, there's a strong countervailing policy inference in Puerto Rico's constitution that suggests that Puerto Rico should not have to follow this statute. This court has held that when interpreting what's locally inapplicable, then we have to apply a textual analysis and look at Congress's intent. Nowhere in the Federal Death Penalty Act does Congress say that it wants to apply it to Puerto Rico.
But what about the applicable statute that imposes the death penalty? Does that apply to Puerto Rico?
Yes, Your Honor.
So you said the statute that opposes death sentence federal death sentence on Puerto Rico in Puerto Ricans cannot be executed.
Your Honor, and my colleague is going to talk. I'm sorry. No, that is not my argument. Our position is that even if a federal statute is constitutional, it does not make the execution of that statute constitutional. That is precisely why we have a due process protection in the Constitution, and my colleague will be addressing those due process concerns. And so although the federal statute imposes the death penalty, the special relationship between the United States and Puerto Rico precludes the application of that statute. Now, Puerto Rico's constitution was also ratified by Congress. It was the understanding of the people of Puerto Rico that when Congress made ratifications to its constitution, but did not amend the death penalty portion of that constitution, that they were now joining the United States with that death penalty prohibition intact.
Well, that meant that the death penalty prohibition is intact within the Puerto Rican government and territory in itself. But the federal, they didn't say that the federal penalty shouldn't apply to Puerto Rico. They just said the Puerto Rican government itself will not enact any death penalty statute.
That's correct, Your Honor. But we believe that the national import of the death penalty sentence, as the respondent has claimed,
national which national? Puerto Rican national?
47, Congress said that they would interpret silence in a statute to give Puerto Rico some leeway in legislating those affairs. And so it was the understanding of Congress when the Constitution was ratified.
But how does that line up with the default language in the statute?
And I believe you're referencing that the federal statute should apply if there's if the intent is unclear, correct? Your Honor, the rule that we propose that this court adopt is that when the statute is silent.
You want us to make our rule as opposed to the Congress's rule?
No, Your Honor. Congress has not been clear, and that's the matter that's before us today. The Congress has not been clear on whether or not they want the Federal Death Penalty Act to apply to Puerto Rico. Additionally, there's a strong countervailing policy reason why it should not. Puerto Rico made it very clear that they do not want the death penalty to be executed within their territory, and Congress has been silent on whether or not that should apply. And so we believe that taken together, this court should strike down that application. But even if we assume that the intent is there, and even if we assume that this should be applied, this also violates the International Covenant for Civil and Political Rights. That treaty was ratified by the United States in 1992. And Article 6 of that treaty says that everyone has a right to individual life. The FDPA is in clear contravention of that article.
But didn't the United States sign on the total package? I thought it existed the death portion of it.
That is correct, Your Honor. The United States has attempted to carve out exceptions.
But I thought it did.
It did, Your Honor. It did, Your Honor. But if you look at the language that was used when it was signed, and when the Senate came before, when the U.S. government came before the Senate during the ratification, the government itself said that this was meant to impose certain restrictions locally. Now, if there are constitutional violations, that is of course not what we're asking the court to uphold, but the ICCPR has given standing, a district court in this great state of Florida gave a defendant standing under the ICCPR for the same article violation that is before the court today. So we believe that in the ratification of this treaty, that the United States...
referring to the juvenile...
this is
Given that circumstance, and given the fact that Puerto Rico as a community is a distinguished, marginalized group when it comes to lawmaking, it immediately triggers a substantive due process issue under the 14th Amendment. The 14th Amendment says that the government cannot deprive a person of life without due process. And this is a cornerstone of our democratic process in the sense that...
So you're saying Mr. Pujols wouldn't have due process under the 14th Amendment?
He should, but in this case he's not.
Would not? Why so?
There are a couple of reasons. First, the right to life is a fundamental right. We've identified
That's a fundamental right for every American citizen.
Yes, Your Honor. From the Declaration of Independence, we've seen life as an inalienable right, and that's also been translated into the 14th Amendment. And it's not the question of whether a person's life can be taken away. It's the question of whether there's a process in that. And we believe that in this case there isn't, for several reasons. On one hand, you have the fundamental right issue, but on the other hand, you have the fact that Puerto Rican community is marginalized, both from the executive, judicial, and legislative branch of the federal government. On one hand...
Isn't that a political question?
No, Your Honor. It is a legal question because it deals with the legitimacy of applying that law to a community of U.S. citizens. And in that legitimacy is the question of consent. And to continue with that, from a legislative perspective, there's 3.6 million U.S. citizens who are not fully and effectively represented in the lawmaking process and who weren't fully represented when the FDPA was passed.
That includes the citizens of Washington, D.C.?
Your Honor, it's possible, but in this case, our client is from Puerto Rico.
Oh, yeah, okay.
Along those lines, for instance, the only representation that these 3.6 million people have in the legislative process is a resident commissioner that has no voice or vote in the process. Second, when it comes to the executive branch, when we come to sign the FDPA, again, Puerto Ricans do not have the right to vote for the president. So there, in terms of having a heightened level of reliability on the process.
So why should any federal law apply to Puerto Rico then, in that case?
Your Honor, in this case, we're specifically focused on the substantive due process issue concerned with Puerto Rico because it has to do with the right to life. Basically, if we're allowed to apply the FDPA in Puerto Rico, we're saying that millions of citizens are potentially subjected to expressly stated that the death penalty would not exist within Puerto Rico. Furthermore, this is a question of whether millions of people could potentially be subjected to execution without any type of voice or representation in the law that is meant to authorize this. And as a cornerstone of the American legal system is the idea of consent. And in this case, in either state, from the law, creation of the law to its enactment, and even within the jury itself, there is no representative and effective voice from the Puerto Rican people. So for example, at the jury level, for a federal court system, people need to speak English and be able to follow the legalese of the court. Only 25% of the people in Puerto Rico are allowed to do so. Your Honor, I see that I've run out of time. May I finish my thought?
Wrap it up, one sentence.
And basically, the fact that there isn't representation, effective representation in the jury of the peers of, for instance, our client, Mr. Pucot, shows that there is a clear reason for why the FDPA should not be applied in Puerto Rico. Thank you.
Thank you. Thank you. You may proceed. Please proceed.
Good afternoon. My name is Lynn Vasquez, and on behalf of the respondent, I will be addressing the issue of whether the Federal Death Penalty Act should apply to the residents of the Commonwealth of Puerto Rico. The Federal Death Penalty Act should apply to all United States citizens, including those residing in the Commonwealth of Puerto Rico, for the following. First, Congress intended for the Federal Death Penalty Act to apply to the Commonwealth of Puerto Rico as punishment for the violation of federal crime. Second, there is no substantive due process violation by the application of federal law to the Commonwealth. And third, the ICCPR, a non-self-executing treaty, itself states that there is an allowance of the punishment of death for only the most serious crimes, just as is the case in this scenario. Your Honors, in light of the foregoing, the respondent respectfully urges this court to affirm the holding of the First Circuit and find that the Federal Death Penalty Act does apply to the residents of Puerto Rico, including petitioner. To my first point, concerning the application of the Federal Death Penalty Act as punishment of federal crimes. First and foremost, Your Honors, the Puerto Rican Federal Relation Act creates a general rule that applies all federal laws to the Commonwealth of Puerto Rico. There is an exception in the language of this provision that states that those which are locally inapplicable will not apply. However, of the United States Code, specifically in the underlying action, we have reference to the two crimes committed by the which are Title 18, Sections 924 and Sections 1513. Both of these provisions, 924 specifically, is extended to the Commonwealth of Puerto Rico in its statutory language. Furthermore, Section 1513 includes extraterritorial reach. These substantive portions, as provisions of the Federal Criminal Code, do directly apply to the residents of Puerto Rico as United States citizens. Furthermore, it is the Federal Death Penalty Act which applies broadly as punishment for these only most heinous crimes. There is, in fact, no locality designation in that Federal Death Penalty Act.
And you think that there is no import to the fact that Puerto Ricans have not had a voice in those decisions by Congress?
Your Honor, that speaks to the third issue raised by petitioner concerning the lack of representation and the substantive due process violations. Specifically, there must be a designation for substantive due process violation of a fundamental right. While that does invoke certain constitutional protections, the lack of a representative in Congress with full voting power, this is not something that falls under the purview of substantive due process. Rather, the argument to be made may be one of equal protection, that there is a marginalized class here. However, as required by this court in Coramons of the United States, if it is not a racial class or a national origin class, again, United States citizens are those who reside in Puerto Rico that are being considered in this case. Therefore, any unequal application of law is not done based on race or nationality because we are all United States citizens.
So you think whether a particular people had a voice in the enactment of the law, that is of no import?
No, Your Honor. There is an important recognition to be made of the fact that there is a differing level of voice. However, this is not due to the mandate of law from the federal government simply limiting the amount of expression for the people of Puerto Rico, but rather...
So if tomorrow Congress decides to issue a law making the income tax laws applicable to the residents of Puerto Rico, no, they have not had a say in Congress for Congress to do that. Would that be okay?
Your Honor, that would be dependent upon, again, the understanding of the Federal Relations Act, the Puerto Rican Federal Relations Act.
Based on the federal, on the resident commissioners with 0 votes, so they have increased the presence in the Congress with 0 votes. You realize that if Puerto Rico were to be a state, probably have more representatives in Congress than about 23 of the United States. In other words, Puerto Rico will be one of the biggest voting blocks in the United States Congress.
Yes, Your Honor.
So then at that time, then you can extend income tax to Puerto Rico because now you have a bigger voice than about 23 of the other states.
That is precisely correct, Your Honor. If there was a completion of the statehood process, then that would immediately invoke the Article 2 provisions, which would require full representation, as well as mentioned by petitioners, a right to vote for president and so on and so forth. However, the same would go if there was an increase of taxation. This would necessarily require an equal representation for the people of Puerto Rico. However, until those circumstances arise, there is no need for a strict scrutiny analysis for that deprivation. Furthermore, Your Honors, this returns me to the fact that several applications of law have been considered. In the First Circuit, the U.S. v. Quinones v. United States in 1985, the court specifically applied a scenario which is much similar to the petitioners in that the Omnibus Crime Act, which extended wiretapping availability, applied.
But you've heard the argument against that in that wiretap, even though it was not explicitly applicable to Puerto Rico, and even though there was a constitutional prohibition in the Puerto Rican Constitution, wiretapping, which was really an evidentiary issue as to whether or not the wiretaps could be introduced in evidence, the argument is that it does not equate to the deprivation of life. And so therefore it's easier to make that decision as opposed to one so, what I call a fundamental right, i.e. the right to live.
Your Honor, the government respectfully disagrees with that viewpoint, that there is a requirement to give a heightened scrutiny solely because of the outcome of an extension of law to the federal residents in Puerto Rico. There are two different analyses that must be made by this court. The first concerns the extension of federal law, regardless of the outcome, regardless of what the circumstances are. If that application is extended, then what arises is a substantive due process issue, if there is in fact a deprivation of life. To merge the issues confounds the problems for this court and presented to this court. And for that reason, they should be separated. No specific application or exception for the Federal Death Penalty Act. However, again, it is for this court to look to the congressional intent, which the government argues is present in the application of federal crimes. Congress's purpose in extending those federal crimes is the same that goes for any citizen of the United States in any state, and that is to protect from the most heinous crimes. The procedural aspect of the federal death penalty merely follows this punishment. The petitioner argues that there is, for some reason, some due process issue which has risen from that. However, what's important to remember is that the procedural due process guarantees of the Fifth Amendment of the Constitution, which apply to the federal government, in fact, do extend those protections to the people of Puerto Rico. It is not a mandate that all Puerto Rican residents may be killed, but rather that there is a prosecutor.
Yeah, but we cannot overlook or take lightly the fact that in all these laws that are being passed, the people that have been affected by those laws have not had the opportunity to say something with respect to those laws. And I think that's what the focus is when they're talking about a violation of substantive due process.
That is correct, Your Honor. There is a suggestion by the petitioner that there is a recognition of the lack of representation. However, under this court's analysis, that representation must be considered not as something that is fundamental because Article 2 of the Constitution grants the process and the option to participate in the political process to residents of the states. That is specifically the constraint put on this court by the Constitution. So without statehood, there cannot be full representation in Congress.
So they're still second-class citizens, basically.
No, Your Honor. They have a different locality, which is a determination of how the status interacts.
Which determines the status as second-class citizens because of their inability to vote.
Your Honor, I respectfully disagree with the statement that they are.
You don't have to even respectfully disagree. You can just disagree.
Respectfully, nonetheless, Your Honor. I respectfully disagree that there is, in fact, not a second-class status, but a different class status. It is important to note that what is the same...
They're separate but equal, in other words.
No, Your Honor, they are not separate but equal. They are merely different because there is clearly a difference in the unique relationship between the two localities. What is important to remember, though, is in their representation as United States citizens, residents of Puerto Rico are entitled to the same voice and application of law that any of the several states would have. And I realize, as the court has mentioned, that there is a difference with this representation. However, the representation is something that is a different analysis because of their status as a commonwealth. This Commonwealth, again, Your Honors, was agreed to in a compact at the time of the creation of this Puerto Rican Federal Relations Act. It's really important before this court as something that protects all United States citizens.
There's no arbitrary deprivation, just deprivation nevertheless.
Yes, Your Honor. However, if I may briefly conclude, as I see my time has expired, the analysis, may I briefly conclude, Your Honor?
You may.
Thank you, Your Honors.
Briefly.
Yes.
One sentence.
In light of the fact that there is, in fact, an analysis to be applied to the court where it must consider the compelling governmental interests, the respondent respectfully urges the Federal Death Penalty Act should apply to residents of Puerto Rico as United States citizens. Thank you, Your Honors.
Thank you very much.
Thank you.
I wonder who's number one. I wonder who's number one. I'll clear the court, but we'll try to find a place. I'll clear the court. We're going to be. We'll do it back here. Okay, we got to do it.